can you see it? Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Hey everybody, we're going around the world. Listen, I was getting ready to do who's Nate? Nate DJ said, "Good day, everyone, in spite of." Exactly, Nate. Hey, good morning, Nate. Listen, guys, there's a lot of stuff going on. I was getting ready to do the Idaho, and I noticed that they said this part of the session is closed. Look at this, y'all. Look. Y'all see that? Look at that. According to Kathy Russo of Law and Crime, it looks like they're having some. Hold on a second. Hold on. I got a public safety announcement just went by just now. Hold on. She said, okay, hold on a second. Let's see. Okay, hold on a second, y'all. I'm trying to get the information from. Just one second. Okay, Kathy Russo says, she said, hold on. She said today is a day 2 hearing in Idaho for Brian Kohlberg case. The judge has closed the courtroom because some presentation will be under seal. The live feed will go off and on during the day, depending on what's being discussed. The judge is concerned about um, about tainting a jury now that the case have been moved to Boise, after worries that they couldn't get a fair jury in the original jurisdiction. Y'all guys heard that? So the video is gonna go in and out. But in the meantime, your girl has sent me some. Melissa, where you been? Melissa, where have you been? You've been MIA. I can't even fight with you. I needed a fighter, so you wasn't around. Oh my God, Melissa, you have not been around. Where have you been? I needed my fighting Melissa. You've been taking an emotional social break? Okay, all right. Hey, Envitor says, good morning, Sylvia and Chad. Hope you're having a good day. It's a good day so far. Okay, y'all, let's go. We're going to go, CMT send me some court places for us to travel through. So we're going to go do some, let's go do some first appearances. All right, we got some first appearance. Oh, Clayton County, y'all. Wow, we need this because this is where my kids is at.
I know you are right at this moment, but this happened allegedly happened while in jail. How long have you been in jail right now?
3 years.
3 years.
3
Okay.
years.
All right. What I'm going to do is put in an order to appoint a public defender for you, and then if you end up hiring a private attorney, they can swap out very easily. But this at least goes ahead and assigns somebody so you're not delayed in the process. Okay. All right, and they'll take care of everything this morning. Thank you, sir.
Did y'all hear that? He's been in jail for 3 years.
Good morning, sir. Give me just a second here.
Yeah, I was at this court. That's where my case is. And I go to court on the I go for my case in February, y'all. Finally, I go to court.
Okay, and can you state your full name for me?
Yvonne Williams.
All right, Mr. Williams. You have got one charge, that is battery. The criminal records index indicates you were given 5 years of probation back in 2022 in Fulton County Superior Court. Because of that probation status, I don't have the authority to give you a bond on a battery charge this morning. The preliminary hearing in your case would be scheduled for February the 18th, unless you want to waive that hearing this morning. Do you want me to schedule you for February the 18th?
Yes, sir.
All right, so we'll put you down for February the 18th. And do you want to be represented by a public defender?
I already have an attorney on the rest of my charges, Thomas Montelli. So most likely I would want him to represent me on this case too.
Okay, and I know that you are, how long have you been incarcerated right now?
5 years.
Okay.
5 years?
5 years.
All right, so I'll put the order in to have them assign somebody. They may
5
assign the same
years,
person.
y'all?
It'll be up to them. But
Without a
I will
trial?
put that order in to get an attorney assigned to you.
5
All right,
years
they'll take care of everything.
trial.
Thank you, sir.
Crazy.
And the last one, Callaway.
This is crazy, y'all. We thought Fulton was bad.
All right, good morning, sir. Can you state your name for me?
Oh, Callaway.
All right, Mr. Callaway, you have one charge, that is battery. That bond is going to be $4,000, and that includes a special condition that while out on bond, you're to stay away from and have no contact with Will Wright. The preliminary hearing in your case will be scheduled for February the 18th, unless you want to waive that hearing this morning. Do you want me to schedule you for February the 18th?
Sure.
All right, so we'll put you down for February the 18th. And I am going to assign an attorney to represent you. And they'll take care of everything. Thank you, sir.
Thank you.
It's crazy. It's crazy. You told me away. I told me to.
Wow, 5 years in jail with no
Yes, they
trial.
do. They have sex. And that's all, Your Honor.
Okay, yeah, I think the only other one I had, I think it said he's out on bond. Cruz.
Yes, he's out on bond.
Out on bond. Okay. All right. Thank you, guys. I'll see you tomorrow.
Whoa, Clayton County. Oh my God, y'all. Remember I was saying how I had not heard anything from them? Now that explains it all. Lord have mercy, Jesus. Woo! Father God in heaven. We definitely got to pray for that county as well. That is crazy. 5 years in jail and no hearing, no trial. 5 years. And he had a battery. Oh my God. A battery. Oh my God, y'all. This is ridiculous. This justice system, man. That's why sometimes to live in states like New York, and because they get that stuff done. Boom, 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 boom. New York, they don't play that. But Georgia, Lord have mercy. Good morning, Sunday. This is ridiculous. Yeah, that's terrible. All right, we're going and we're taking another trip. We're going someplace else, guys. So travel through the court system. So now we're going to take a trip to Washington. Okay. All right, here we go. We're going to Washington. This person has a interpreter.
I then gave him a chance to get on probation and show me that he was gonna test and do what he's supposed to do.
بعديها أعطيته فرصة إنه يكون تحت
This is
المراقبة
Michigan,
ويقوم
y'all.
بعمل
State of
الفحوصات
Michigan, sorry.
اللازمة.
This is
Instead of
Judge
doing that,
Washington,
he
State
did
of
not
Michigan.
test at all.
بدل ما يمتثل الأوامر لم يقم بعمل أي فحص واحد حتى.
So on January 9th, I explained how non-compliant he was.
فبتاريخ 9/1 أنا قمت بإعطائه
Jim
تفسير
Miller, but 5
تفصيلي
years, Tank.
عن
5 years.
عدم امتثاله
Seriously, 5
للأوامر.
years, Tank.
Told him he had to
Jim Miller.
test within 24 hours and to maintain compliance with his testing.
وقلت له أنه يجب عليه عمل فحص خلال 24 ساعة وأن يلتزم بباقي الشروط للفحص.
He tested within the 24 hours and then decided, I guess he had had enough of that.
فقام بالفعل بعمل فحص خلال 24 ساعة لكنه يبدو أنه قرر بعد ذلك أنه لا حاجة لعمل فحوصات أخرى.
I was very clear that there would be no more excuses.
وكنت واضحة معه أنني لن أقبل منه أي أعذار أخرى.
He then also failed to enroll in a dual diagnosis program that he was supposed to enroll in.
Here's a lot of
أيضا
things here.
فشل في أن يسجل في برنامج Dual Diagnosis Program وأنا أمرته أن يعمل ذلك.
Therefore, at this point in time, Mr. Awahari,
لذلك في هذا الوقت سيد لاهري
I will give you a minor break, but it's not what you're going to want.
سوف أعطيك يعني مهلة قصيرة ليس بالمدة التي أنت تطلبها.
He at least did start going to his AA meetings, so I'll give him some consideration of that.
آخذ بعين الاعتبار أنك تذهب إلى اجتماعات ال AA.
It is the sentence of this court, sir, that you serve 10 days in a Washtenaw County jail. When can you turn yourself in?
فأنا أصدر الحكم عليك بقضاء 10 أيام في سجن واشينا كاونتي. متى ممكن تذهب؟
متى تشتوني اليوم أو بكرة الصبح أروح عادي؟
I can go today or tomorrow morning.
Please turn yourself in by 8 a.m. tomorrow morning.
8 a.m. That's
طيب
early.
معك
That's
يعني
when I
الساعة
slept in.
8 صباحا قبل 8 صباحا اذهب إلى هناك وسلم نفسك.
Your probation is continued, so you either get it together or you'll be serving more time.
فأنت يعني لسه في فترة البروبيشن المراقبة، إما تلتزم بهذه الشروط أو تكون مدة الحكم عليك بالسجن أطول.
When you get out, you need to continue your testing every time that your number or your color comes up.
بعد ما تخرج من السجن يجب أن تلتزم بعمل الفحوصات اللازمة عندما يأتي دورك، يأتي رقمك، يأتي دورك، يجب أن تذهب في هذاك الوقت المحدد.
You understand, sir?
مفهوم سيدي؟
نعم.
Yes.
Thank you. I'll see you back here on March 27th at 10 a.m. to see how things are going.
طيب أشوفك هنا في المحكمة بتاريخ 27/3 الساعة 10 صباحا لمعرفة كيف تسير الأمور.
Thank
Thank you. You're welcome.
Okay, so let's see.
You're all set, Mr. Nan. Thank you for your services today.
Thank you for using our service. مع السلامة. Goodbye.
أصلاً.
Bye-bye. The court will call the case of the state of Michigan versus Derek Radecki, case number 24FB 1410.
Tiffany works for the people.
She gets things done.
Assistant Public Defender Davi Liba for Mr. Radecki. Mr. Radecki, could you state your name, sir?
I don't see Mr. Radaki.
Mr. Radecki.
Sorry, my phone was acting up. Derek Radecki.
Radecki. Thank you, Mr. Radecki.
No problem.
All right, so you're here for sentencing today. Have you had a chance to review the report with your client now, Mr. Udo?
I have, Your Honor. I don't think we have any modifications or deletions to the factual parts of the report. I think it does lay out what happened. And Mr. Radecki's remorse for it happened very well. The only modification to the sense we would request that Mr. Radecki is requesting permission to possess weapons for hunting purposes only.
Let's see what she say.
Ms. Woods?
Judge, I've also had an opportunity to read the recommendation in the PSIR, and I'd ask the court to follow the recommendations within that report. Thank you.
What's the
You have a
recommendation?
response to the request to be able to use weapons for hunting purposes.
Judge, I would object to any weapons being used when someone's on probation.
Thank you. Mr. Radecki, anything you want to say today? Radecki. I'm sorry, I'm not sure.
It is Radecki.
Right.
Well, I have 14 acres of property in Southern Ohio, so that's the only reason I have a shotgun and a small rifle that I take with me, and we hunt. That's about it. I don't take them anywhere except for whenever I travel down south. It kind of would be an inconvenience to not be able to, because that's kind of what we do for fun, I guess. But
Fun.
you know, I understand whatever choice you guys need to make needs to be made.
Well, there's a no.
Oh, and I am remorseful for what happened that day. I was in the wrong. I was extremely stressed out. That was not the first car that she's wrecked. She has wrecked 2 and blown up 1 or 2.
Dang. Who
And
is
we've
she?
only been together for 7 years. So I bought 5 cars now.
Dang, you don't need to be with
Just
her.
for her.
So, Mr. Radecki, when I was reviewing this report, it says here that you threatened to beat her up.
Uh-oh.
No,
You listened to the commands, you interfered with the investigation, and that's how you got detained, but you started resisting.
I never threatened to beat anyone up. As far I know, I didn't. This is the first I'm actually hearing of that, in the whole time that I've been going to court for it.
Well, it's right
I
here.
know I did resist by passively resisted. I put my hands behind my back and kind of just stood there. I didn't try to run. I didn't,
Well, I'll read it to you. One of these vehicles was driven by Kennedy Estep. While I was talking with the involved parties, Kennedy's boyfriend, Derek Radecki, drove up to the scene. Derek threatened to beat up the at-fault driver, refused to listen to my commands, and interfere with my investigation. I attempted to detain Derek, but he exhibited resistance up to the level of active resistance. With the help of Deputy Cuso of the Washington County Sheriff's Office, I detained Derek in custody. And it, of course, goes on from there. But you later did apologize, among saying some other things. And then you got dropped off at your vehicle and it was submitted to the prosecutor's office. But I'm surprised you
It was
had
never
no.
read. Oops, sorry.
Go ahead.
It was never read to me in that way. So I was never, I never was told that it was, I resisted to the point of active resistance. I guess you would have to see the video, but at this point it doesn't matter. It is what it is. But I definitely didn't actively resist. I put both my hands behind my back. I had my vape in my hand. And after they cuffed me, they had to take my vape out of my hand because I had my vape in my hand still. So I wasn't trying to like, I think I was wrong, definitely. But I think that it was just a heated situation. And I feel like the words that I'm hearing now in the report are different from what I've been being told because I wasn't read that directly. So it's just a little interesting.
Yeah,
You know
I
what?
find it
You're
interesting.
lying.
And it wasn't my girlfriend. I know we found out she was the at-fault driver after. I did show up mad at whoever it was that caused the accident, but not thinking it was her, if that makes any sense. Like I thought someone else cut her off because that's what she had told me on the phone. And then I found out later that she had caused the accident.
Right. Is there anything else you'd like to say before I begin the sentencing, sir?
No, just that I apologize, and I know that I was in the wrong for the most part in this situation.
Right. Mr. Radke, it is the sentence of this court that you served 365 days in the Washtenaw County Jail. Credit for 0 days served. The balance is suspended. You're on probation for 9 months. You will be eligible for early discharge if you complete all of the rest of my orders within the first half of that 9 months. Fines and court costs in this case for a total of $525, $30 per month probation oversight fee. You to report to the probation officer monthly via the online reporting platform and report during the 4th week of each month. You're to meet with probation when and where directed, including any and all home visits. You're to complete the ABR. How long is the anger management program, please?
So he doesn't have to serve any time in jail. He's getting probation 9 months.
Mr. Pappenhagen or Ms. Johnson, either one, please.
What program was he referred to, Your Honor? Excuse me. Good morning.
He's referred to the ABR Anger Habits Program.
So that is a 1-day program
One day.
online.
Okay. All right. And the Impulse program is how long? Do you know?
If that goes with Crossroads, it's also a 1-day program, but they break it up into 2 days. So there's like 4 hours each session.
Okay. And I'm not familiar with the distinction between these two programs. And I'm trying to figure out if the Impulse would be better for him.
So the impulse control program with Crossroads takes a little longer to get into because they only run them every 2 to 3 months. The ABR program you can get into like tomorrow if you call today.
All right, thank you.
You're welcome.
The defendant is to complete the ABR Anger Habits Program within 90 days of the sentence. No assaultive or threatening behavior towards anyone. You're to submit to and pay and be responsible for random drug and alcohol tests as requested by the court. None are being ordered at this time. No use of possession of alcohol, marijuana, illegal drugs, or being in the presence of anyone using them. So, given the nature of this particular offense, you can complete all this stuff and get yourself off probation and try to get to hunting. I believe hunting season doesn't start until November anyway. So if you finish what you need to do, I don't know what Wisconsin's laws are, so I don't know that. But if you finish what you need to do, you can be off probation in 4.5 months. I would suggest you do that because I am going to order that you not have any weapons or be in possession of any or be present with anyone using them or and that you have a review before me in 90 days on April 24th,
So he can get a gun.
2025 at 10 o'clock a.m.
So he can get a gun.
Do you have any questions, sir?
Nope.
All right. I'll see you on April 24th. Good luck to you.
Thank you.
State of Michigan versus DeQuavion Wells, 23 FB 1141.
Tiffany Woods for the people.
Assistant Public Defender Davi Leba for Mr. Wells. Mr. Wells, could you state your name, sir?
DeQuavion Wells.
Thank you. Have you had a chance to review the report with your client now?
I have, Your Honor. Mr. Wells. I have reviewed the report with Mr. Wells, Your Honor. We would agree with the recommendation to extend probation for 12 months for Mr. Wells to complete the MRT program.
Anything from the people?
Bingo.
No, Judge, I would ask you to use court discretion.
Mr. Wells, anything you want to say, sir?
Your Honor, I actually broke my phone. That's why I signed up for the MRT class, like how I told you. You know, I'm not even using my phone right now. Last time I had missed my court date and whatnot, it's because I didn't have a phone. Like, so I'm finna get all that situated and just wrap all this up for us, Your Honor. I know you're tired of seeing me.
All right, Mr. Wells, I'll extend your probation for 12 months. Complete the MRT. I'm gonna do a review in 60 days. So that'll
I
put
know
you
you're
on
tired of
March
seeing me,
27,
Judge.
2025 at 10 o'clock. You should be in the MRT and have some of the steps completed by then, okay, Mr. Wells?
Yes, ma'am.
All right, thank you. Take care of yourself.
You have a blessed day, Your Honor.
You too.
Judge know him for
The
real.
court will call the matter of Gavin Wells, 24 FB 1194.
Tiffany Woods for the people.
Matt Mansour, Assistant Public Defender on behalf of Mr. Wells. Mr. Wells, if you are on, can you unmute and state your name for the judge, please?
Another Wells? Didn't they just have
Mr. Gavin Wells,
Speaking.
please turn on your screen.
I got
Please state your name.
They just told him.
I'm sorry, I didn't catch anything before I came in. My name is Gavin Wells.
Thank you. All right.
This court is wild, y'all.
Mr. Wells was not placed on probation at the time that he was sentenced and given an opportunity to try just pay off fines and costs, complete the ABR impulse control program. And it looks like he hasn't done any of those things.
Did that man just show his
That is incorrect.
lower part? What is Malcolm showing us his lower part? Look at him. Look at Malcolm.
Do I
Look.
have an attorney present? Or
I thought you spoke with an attorney. Didn't you go in the room and speak with an attorney?
no, I haven't spoken with any attorney.
No, Your Honor. We reached out to Mr. Wells.
I passed this. He wanted me to
He's
just
showing us his
handle this today, and I passed it
stuff.
so he could speak to an attorney. All right, we'll put him in a room so that can happen. I'm sorry, Mr. Wells.
What the hell? What the? He's showing us. What in the world? What is Keith Malcolm doing, y'all?
The court will call the matter of Serenity Walker Hardy, case numbers 23S419731 B and
A lot of people. This is a lot of people. And use that profile and rule somebody out just because they're out.
That's
I'm
her.
sorry.
Ms. Walker Hardy, you need to turn down your TV or whatever that background noise is.
Sorry about that.
Tiffany Woods for the people.
Finish.
Assistant Public Defender Davi Leba for
Finish.
Hardy.
I have not finished.
My apologies, Judge.
Apologies.
The court will call the cases of 23W0022 35A and B.
Yeah, this court is wild.
Now, Ms. Woods.
Tiffany Woods for the people.
Assistant Public Defender Davi Lee before Ms. Walker Hardy. Ms. Walker Hardy, can you state your name, ma'am?
Serenity Walker Hardy.
All right, Ms. Walker Hardy is here because she owes the court $895. It looks like she got set up on a $50 payment plan, but I don't see that a single payment has been made.
That is correct, Your Honor. I discussed with Ms. Walker Hardy. She tells me she's going to be making a payment as soon as she can. I explained to her, the significance that she could be held in contempt of court for non-payments and that she needs to begin making payments or file a financial hardship form. Ms. Walker Hardy is informed that she'll be doing that she'll be making payments going forward. Isn't that right, Ms. Walker Hardy?
Yes, I made a $75 payment today.
All right, thank you. She is here on the contempt proceeding today. So I'm going to continue this as a contempt and a show cause on the failure to report, but a contempt on the other charges. So I will continue them as this.
She
So
gonna
Ms.
pay more
Walker
money.
Hardy, you will be here on a show cause on April 24th, 2025 at 10, as well as 2 contempt charges. You need to be making your payments, ma'am, and you need to show up or you can be held in contempt. So you need to show up, okay?
Understood.
All right. So that will be on April 24th, 2025 at 10 a.m. If you show up on those dates and you've been making your payments, then I will.
Thank you, Tank.
Any
Y'all gotta
contempt
say
at this time, not
she
find you in
went found
contempt
this
and give you a standard date where you don't have to show up. Okay?
Understood.
MT be
All
working,
right,
y'all.
thank you. We'll see you then on April 24th at 10 o'clock a.m.
All righty, thank you.
Thank you.
Gotta heat up my food.
What will call the case of the state of Michigan versus Kiera Carpenter, case number 23-00520.
Tiffany Woods for the people.
Assistant Public Defender Davi Lee before Ms. Carpenter. Ms. Carpenter, can you state your name, please?
Kiera Carpenter.
Good morning, Ms. Carpenter.
Good morning.
So, Ms. Carpenter, it looks like you have attended 5 12-step meetings, open 12-step meetings like you were ordered. You've completed a total of 80 hours of community service. Did she pay her RMD? Did she complete the armed DUI class?
Yes,
I see Ms. Carpenter nodding, Your Honor.
Mr. Pappenhage, are you present?
Thank you, Tank.
Mr. Pappenhagen, are you present?
Folks don't know what we're doing over
I'm
here.
present, Your Honor.
Thank you. Did Ms. Carpenter complete, Ms. Kiera Carpenter, in case you weren't present, did she complete her armed DUI class?
She did, Her Honor. She completed it.
All right. And the MAD victim impact panel, she completed that as well?
She did, Your Honor.
All right.
She's a good girl.
And so she was originally ordered to pay $725
100 too.
of court costs and $3,125 of restitution.
Hey, 3,000. What the heck you do?
Did she pay the restitution already?
No, Your Honor, we would be seeking a payment plan.
3,000. Where's she gonna get that from?
Has she made any payments towards her restitution?
I don't believe she's been able to make any payments so far, Your Honor.
Well, I'm not willing to discharge her without having any payments made towards her restitution.
Understood, Your Honor. Would non-reporting be a possibility until she begins making payments?
One second.
Man, she a DUI?
6:35.
It ended in a crash? Oh, okay, okay.
What? So only 1,300 was ordered? Because I put 3,125.
So they got
1 second, please.
they got the wrong amount, y'all.
Then I see counsel and probation and breakout room.
They're doing a breakout room. Because they got the wrong amount. Excuse me, y'all. I can't, if I mute, y'all won't be able to hear what they say. So I'm eating right now. So sorry. But I gotta get my I gotta eat. Cause y'all know, you know your girl gotta eat, y'all. If I don't, I start getting sick. All right, they're on a breakout room because somebody don't know what they're talking about, the amount of money. So they have to figure it out, how much she owes. I like the way Michigan does it. This judge, it seems like she gets things out the way. So far, Michigan got the best system right now for me. All the other ones, we just saw Clayton. Clayton had somebody in jail for 5 years. 5 years and hadn't had a trial for battery. 5 years. He already served his time. Especially simple battery. Because simple battery is only 365 days. He doesn't even have a lawyer to talk for him. I see adventuring. I see. He says common in Georgia. That's because they don't have a lawyer. They like the chain gang people. No, her last name is Washington. See how you don't pay attention, Rachel? I corrected it. I first said Washington, and then I said, oh, no, this is Michigan, and her last name is Washington. So that means somebody's not paying attention in class. The one who wanted to lead the class last live. Wow, for real? 10 years? Wow. Did he do murder or something? $7 years and they got acquittal? Oh my God. Can they sue? They're still in the breakout room. Man, that really messed up on the money amount. Let me mute myself so I could chow down. As Rachel could say, she called it chow down. I never heard that until Rachel told me, so I have to use her word. Chow down. See, Rachel, I remember your word. Chow down. I remember your word. Chow down. That's a Southern thing. That's what Rachel said. Man, they taking a long time. They messed up on the lady's money. I'm gonna be well versed when I stop doing these things because I don't know how to say stuff from the south. Hold on, let's see what Aventurin said. Hold on. I don't even understand what chow. Why do they call it chow down? What is chow? Don't start that. Thank you, Angel's crap, Rachel. Don't start that. Yeah, today is Rachel's day. Today's Rachel's day, y'all. Y'all better stay away from the crossfire. Angel, if you want some of it, you're gonna get it too. All those that's coming in, what we're doing now, we're waiting for the judge to come back. Hey, tall guys. I've never been in the military, so I wouldn't know. But thank you, Angel. She said she don't want no smoke. All right, good people. I've eaten my lunch. Oh, they're back. They're back.
All right. In this particular matter, it appears that we're back on the record in the Kira or Carpenter case. Ms. Carpenter, it appears that your contract somehow left out the $3,125 that was ordered for restitution. So you are going to have to start making some payments on that restitution. It appears it was not your fault that you were not, that was not placed in your contract, although I did order it at the time of the sentencing. Given that it wasn't in your contract, I will give you non-reporting probation, so you no longer need to report, but you do need to make payments on your restitution as well as your fines and costs. And I'll do a review in 90 days to see where you are with respect to this. And then I'll consider at that time, depending on how much you've paid, as to whether or not I will discharge you in 90 days. Does that make sense to you, ma'am?
Yes. Am I still testing?
No, you won't be testing.
Okay.
That
She want to go back to
do
smoking,
the
yo.
non-reporting probation, meaning that you don't even have to reach out to probation. But if something comes up and you get in additional trouble, you're still on probation and it would be a violation. So don't get in any additional trouble. But you do need to pay on your restitution and your fines and costs. If you come back here in 90 days and you're not making any significant payments towards the restitution, then what happens is you can have your probation extended and you can go back non-reporting. So I'm hoping that you can try to get the victims in this case made whole. Okay.
Yes.
I'll see you back here on is there anything else to say, ma'am? I didn't give you that opportunity.
Will I be paying through the same link I was paying through for court cost and
If you were paying by credit card, no, you can't do that. You have to either send it in via a money order or bring in cash. I think we do accept checks, but I'm not positive about that. You can call the clerk's office and they can give you the definitive answer to that. Restitution is handled a little differently. So make sure you reach out so they can give you a definitive answer about that, okay?
okay.
Uh, all right, I'll see you back here. There we go. On April the 24th at 10:00 a.m.
What time?
At 10 a.m.
Okay.
All right. Thank you for doing everything else you were supposed to do. I don't want that to be overshadowed by the whole restitution thing. I do notice that you did everything else you were supposed to do, and that's why I'm giving you the non-reporting probation. You did a great job with that. So thank you for doing it, okay?
Yes, thank you.
You're welcome. See you on April 24th.
All right.
She did everything she's supposed to do, y'all. They messed up and putting their money information on that restitution. That was their fault, not hers. Good morning, Mr. Duncan. They got somebody riding like you, Mr. Duncan. I thought it was you up in there, Mr. Malcolm. I thought that was you, Mr. Duncan. Just joking. I know it wasn't you.
The court will recall the matter of the state of Michigan versus Gavin Wells, case number 24 FB 1194.
Tiffany Witch for the people.
Batman Sword Assistant Public Defender on behalf of Mr. Gavin Wells. Gavin, can you state your name for the judge again, please?
He back. Gavin
Joseph Wells.
Thank you. All right, I do have a certificate of completion for Mr. Gavin Wells of his impulse control class. So that is done. Has he paid his court costs?
No, Your Honor, we're just asking for about 30 days and it should be paid, Your Honor, if you would.
You agree, Mr. Wells?
Yes, ma'am. I just started tradesman in between concrete and framing. So framing job just started. Yes.
Congratulations. All right, Mr.
Thank you.
Wells, what I'll do is I'll bring you back here on March 13th, 2025 at 10. If you've made your payments, you don't even have to show up. You can just be all done, okay?
Okay. Thank you very much, Judge Washington.
Thank you for your patience today, Mr. Wells.
No problem.
I really like this court, y'all.
Take care.
They take care of business over here.
The court will call the case of the state of Michigan versus Keith Malcolm, case number 15S0055. We're here for a review hearing.
Tiffany Woods for the people.
Matthew Mansour, Assistant Public Defender on behalf of Mr. Malcolm. Keith, can you unmute and state your name for the judge?
Keith Malcolm.
Thank you. All right, Mr. Malcolm's here for a review. Let's see, he pled no contest to count 2 with an immediate sentence and fines and costs only. And that was to disturbing the peace
We don't have much.
back in January of
Disturbing the peace?
2021.
Disturbing the peace is not a big deal, y'all. Just got a big mouth.
And then when did he serve 10 days in the Washington County Jail?
Your Honor, I was looking that up actually, and so I'm looking it up through X Jail, and it was broken into segments. So in 21, I see 3 days, and then 17, 16, 2017, 16, and 15. It was all broken into like 1 day, 2 days.
Absolutely not. Not
What is
doing
it?
that.
She said, absolutely not. We're
I'm
not.
sorry, I'm confused, Your Honor.
He's asking for credit for the $275 that he was ordered to pay from the 10 days that he did in 17, 16 years that he was on bench warrant status to us. I'm not giving him that.
Oh, yes, Your Honor. We discussed that too, and I told him it's not
Just pay
how it
$275.
usually works. I gave him the total amount due on this case to close it. I believe what I see on my records is about $405.
Oh, $405.
I said we can make a payment plan if you want to do that, or go a different route if you want to try to apply for like an indigency type form or something. And he understands. So I think he wants to do a payment plan, if that's correct, Mr. Malcolm.
Correct.
And how much can he pay per month on what day?
Mr. Malcolm, the judge wants to know how much can you pay a month, and what day would you like to make those payments? Minimum is $25.
What's the maximum?
I can pay like $75.
On what day of the month, sir?
It'll be the 15th, I guess.
The 15th?
Yeah, can start like in February.
Yes, sir. I'll see you back here on April 24th, 2025 at 10 to see if you're making your payments. Please make your payments, sir. By then, you'll be very close to being done.
Yeah. I mean, still come in even if I haven't paid off?
No, you don't, sir. It will just be closed out if you have it paid off.
Okay, you say April what?
24th.
Okay. All right, thank you, Your Honor.
Thank you. Have a good day. And thank you for your patience today. I know you've been waiting a minute.
No problem.
Have a good day.
She's a
You too.
cool judge, y'all. She's a cool.
The court will call the case of the state of Michigan versus Roche Hannon, 21N00819.
Tiffany Woods for the people. Allison Muller here on behalf of Roche Hannon. Roche, could you unmute and then please state your name?
My name is Roche Hannon.
Thank you, Mr. Hannon. All right, we're supposed to be here for sentencing today.
Look at it.
Yes, Your Honor. I went over the PSIR with Mr. Hannon. We have.
Wow. Who prepared it?
Look at him, y'all.
Your Honor, let me look. I forget if it was Agent Pappin. I think it was Agent Johnson. Let me pull it up.
You like you don't have a care in the world. Good morning, everybody.
It was Agent Johnson that prepared the PSIR for this defendant judge.
Look at him, y'all. Look. What's going on with the lighting? He blowing his nose now. He just woke up. He do look like he just woke up. look. What happened to the judge? We lost the judge. The judge connection is gone. Oh, what's up with homie? Look at him. He looking at you, Rachel. He said, look at Rachel. Oh, okay. She went to the break room. Okay. Thank you. Thank you. I tell you, I got my intern. She paying attention what's happening in the courtroom when I'm not. Hey, Pineapple.
All right, you may proceed.
Thank you, Your Honor. I went over the sentencing report with Mr. Hannon. We have no corrections, modifications, or deletions. We do appreciate the recommendation, and we ask the court to follow it.
Thank you.
What is Keith back?
Judge, I've also had an opportunity to read the PSI
Keith back,
recommendations, and I know whenever they entered into the plea offer, we were asking for probation with mental health services, and that's what we would be asking for today.
Why is Keith back?
Mr. Hannon, is there something you would like to say, sir?
Don't let him say nothing. Please, attorney, don't let
Not really. I'm just knowing now that I can't get off my medication and I gotta apply CMH to be better myself.
All right. So, in this particular case, there was a sentence agreement with the prosecutor's office. Sort of. It wasn't really a sentence agreement. In essence, what it was, he had to plead to the MDLB less than 200 and a referral to probation. It doesn't say he must do probation and mental health services. So the referral was essentially that they come up with what the recommendation is. And restitution was open for 60 days. They haven't recommended that he remain on probation. They recommended that he continue with his CMH services and pay fines and costs. Now, what I can do is monitor that he's continuing with those CH services by doing a review date, and that's what I will do. So, it is the sentence of this court that you serve 93 days in the Washtenaw County Jail, credit for 0 days served. Defendant has the balance of that time suspended, so he will not have to do any additional jail time. I will do fines and court costs in this particular case. It looks like I'm gonna do the minimum fee. He has a plea, so he doesn't really. And this is it is a victim's rights case. So I'm gonna do 125 in fines and costs. He used to continue with his CMH treatment. So it's important that you continue doing these services. If you don't continue them, what's going to happen is I'll have to put you on formal probation. I'm going to do a review in 90 days to make sure you're doing that, okay?
Okay.
That'll be on April 24th, 2025 at 10 o'clock a.m. So that will satisfy the prosecutor's request that an agreement that you continue your CMH services. If you fail to do that, then I'll have to put you in probation. Okay?
Okay.
Okay.
Right. You're gonna have to sign. I'm gonna put that in there. He must sign a release of information so that it can be provided to the probation department so that we can see that you're compliant. So you do need to sign a release of information.
Okay.
Okay.
Okay. Okay.
We'll see you back here on April 24th, 2025 at 10 for a review.
Okay.
All right, thank you, ma'am. God bless.
Okay.
Thank you, sir.
Okay. God bless.
Mr. Malcolm, you're free to go, sir.
He said, Mr. Malcolm, you free to go,
The
sir.
court will call the case of the state of Michigan versus Maria
You'll see him on
Maris, 24S00362, as well as 24S4449598.
Now he's back here.
Tiffany Woods for the people.
Here go
Mr. Plug Fender Don Vlieba on behalf of Ms. Linares. Ms.
Yeah.
Linares, could you please unmute and state your name, ma'am?
Mr. Hannah don't know how to get off. He don't know how to get off, y'all.
Okay.
Could you turn on your video and state your name, Ms. Linares?
Oh, okay.
And could you please state your name, ma'am?
My name is Maria Linares.
Thank you. Ms. Linares, in terms of count 1, is valid.
Yes, Your Honor, and I have provided Ms. Woods with a copy of an insurance policy for Ms. Linares.
Judge, I'm just receiving that. I'm looking at it right now.
Yeah, the sun is coming out over here, so it doesn't look like we're gonna be stuck tomorrow. We're gonna have court, looks like it.
Thank you, Judge. I did have an opportunity to review that, and based on the fact that she's now valid and does have valid insurance, I'm willing to dismiss both of her tickets. It looks like she has a 0362 ticket, and then she has a 9598 ticket. I'd be willing to dismiss that ticket as well.
So you're dismissing both counts in 362, and you're dismissing the failure to stop for a school bus. And
That's
okay.
Wow, she dismissing everything? Wow.
Thank you, Ms. Woods.
Everything.
Thank you so much. Thank you so much, Your Honor.
Much.
You're welcome.
Thank you so much.
You should thank the prosecutor on that one.
Thank you so much, prosecutor.
You're welcome.
All right. We have failure to appears. Oh, there's a phone number that ends in
Who does it look like?
7853. Could you please unmute and tell us your first and last name? Hit *67 to unmute, please. Phone number that ends in 7853. Please hit *67 to unmute your device and tell us your first and last name, or we can't call your case. Or we're gonna call your case, and if you don't unmute, you'll get bench warranted.
Bench warrant.
Yes.
Hurry up,
Can you
unmute.
hear me now?
Yes. What is your first and last name, please?
Wardell Smith.
Thank you, Mr. Wardell Smith.
You hurry up and unmute it there.
Yes. I'm calling to ask for not calling. I'm here asking for a little bit more time to pay off the rest of my restitution.
Let me
my
call your
fine.
case. Let me call your case, sir. One moment.
Okay.
The court will call the case of the state of Michigan versus Wardell Smith, case number 19FB 1450.
Tiffany Woods for the people.
Yes, Wardell Smith.
All right, thank you. Mr. Smith, you're here for a payment plan review. You're supposed to be making payments on this, and I think you're probably know you haven't made any.
Annabelle, he's trying to
So
say
you want additional time to pay this ticket or this I think
Yes,
fine.
yes. This will be the last time. This will be the last time I have it paid. And then this will be the last extension or last thing I need to get this paid. And
How long do you need, sir?
2 months.
I'll see you back here on March 27th, 2020. 5 at 10 a.m. Or I'm sorry, I'll set it for that time. So when you do what you just told me you're gonna do, you should have this paid off. It looks like you have a balance of $230 left. So pay that off, sir.
I will.
All
Thank
right,
you.
take care of yourself. Bye-bye.
Okay, you too. Thank you.
You're welcome. Well,
What day did you say?
I'm sorry, what did you say, sir?
Oh, I didn't hear the day, the date that you.
Oh, I said March 27th, 2025 at 10 o'clock a.m.
Okay,
All right, thank you.
thank you. You have a good one.
You too.
Hey, Charles. Look, Mr. Duncan, you know what you was trying to say. You know it. Stop it.
The court will call the matter of William Morgan, 24S4424977.
Tiffany Woods for the people.
Today is the day and time scheduled for a pretrial in this matter. I think Ms. Moeller, is this your matter? I don't know whose matter it is.
Yeah, I can step in. I tried to give, this is Matthew Mansour, Assistant Public Defender on behalf of Mr. Morgan. I tried to give Mr. Morgan a call yesterday and the phone number was disconnected.
All right, the defendant is supposed to be here on a pretrial today. The defendant has failed to show the defendant is still suspended. What is your request, Ms. Woods?
Judge, I'd ask for a bench warrant at this time.
Oh, man. Bench warrant. Bench warrant.
Bench warrant to issue. We'll make it $1,000, 10%. You should reach out to your, well, I guess you don't know how, maybe send your client a letter so that your client can call in and try to get this bench warrant recalled and address his license.
Okay, thank you, Your Honor.
Bench warrant.
You're welcome. We'll call the matters of Tania Nathan, case numbers 24S44398A for pretrial, as well as 23W004770 for show cause, and 24S443989B for pre-hearing conference.
Tiffany Woods for the people.
Matt Mansour, Assistant Public Defender on behalf of Miss Nathan, Your Honor. The phone was disconnected.
Well, what I can say about Miss Nathan is she's not valid still, but she does seem to have a restricted license. Ms. Woods, what is your request?
Judge, since she's failed to appear today, I would ask for a bench warrant.
Given that she has a restricted license at this time, her charge is, let's see, the pretrial is for a invalid license and she's got to restrict it. That's the only thing I could issue a bench warrant on at this time anyway. I'm not gonna do that. I'm gonna do a show cause and give her an opportunity to show up here. If she fails to show, the next time a bench warrant will issue. I'm gonna schedule this for March 6th, 2025 at 9:00 a.m. for a show cause and pretrial in the A ticket. And pre-hearing conference and show cause on the other ticket. Actually, what I'm gonna do in 24S443989B, I'll give her one more chance. Is I will do that as a pre-hearing conference and show cause. If she fails to appear again, she'll get defaulted. We'll call the case of AND Transport 20S3737293.
Tiffany Woods for the people.
Defendant has failed to appear on 3 separate occasions for the magistrate. On this ticket, defendant is found in contempt. To the extent that we can find out who the resident agent is, we will be issuing a bench warrant. $3,000, 10%. We'll call the matters of Nakia Derrickson, 17S3169598 and B for contempt on both matters.
Tiffany Woods for the people.
Defendant has failed to appear on 3 separate occasions before the magistrate and has failed to appear and or pay here today. Contempt is found. Well, let me, Miss Reporter, do you see whether they've made any payments in either of these tickets, Ms. Derrickson? $6,000, 10% in the A ticket, bench warrant to issue, and $4,000, 10% in the B ticket, bench warrant to issue. Sure. Okay. They're supposed to be here. All right. The court will call the matters of the state of Michigan versus Sami Abdelatif, case numbers 23S00844 and 4320-235.
Tiffany Woods for the people.
And Matthew Mansour, Assistant Public Defender, on behalf of Mr. Abdelatif, Your Honor.
All right. It appears that Mr. Delatif has not made a payment. He made a payment in November. It looks like $30 in case number 23S00844. But he hasn't made any payments since then. And I think that was after he told me that other courts come first.
Your Honor, if I, I don't remember him saying that, but if I may, I spoke with him last night, and I had him pay on the case 23S-00844. He paid $200. I told him if he entered into a payment plan, I believe in November, of $50. I told him if he pays up to $200, I believe he'd be all caught up and doesn't have to show up today. I hope I didn't give him the wrong advice, but I know he made $200 payment last night. He actually sent me a confirmation of it too.
Yes, he is correct. I'll move this over to April 24th, 2025 at 10 a.m.
Thank you. Your Honor, is it possible, because he was kind of confused on his cases, he didn't know how much is exactly owed, because I think he's gonna pay it off very close. I only see $95 on the one that's ending in 844. Do you by any chance have a total that I could tell him so he can pay it and be done with this?
Yes, let me find out for you.
Thank you.
You know, I noticed one thing about this court stuff. It's all about money, y'all. It's all about money. So if you're poor, you're done.
$370 is the total.
$370, and this will all be closed. Everything.
Correct.
Thank you, Your Honor. Thanks for taking the time.
Thank you. If he pays it off, he doesn't have to be here, obviously.
Okay, thank you.
Court will call the case of Jamar Brandon, case number 0800. Let me look it up. Sorry. All right, 08S00058.
Tiffany Woods for the people.
Allison Muller here on behalf of Mr. Brandon. Your Honor, unfortunately, it's the same as last time. I have not been able to get in contact with him about this set-aside hearing.
Bench warrant.
All right, defendant has failed to appear for the second time. The motion to set aside is dismissed. Without prejudice.
So that means he could file it again.
The people call the case of the state of Michigan versus Warner Threats. Case number 21S00413.
Do the crime, serve the time.
Tiffany Woods for the people.
Matt Mansour, Assistant Public Defender, on behalf of Mr. Threats. Your Honor, I called and left a voicemail and have not received any callback.
Mr. Threats hasn't made any payments since his last court date, which was November 21st, when he had made $100 payment. And I scheduled this one for a show cause because he was not caught up. So defendant has failed to appear and failed to pay. Defendant failed to show cause why he should not be held in contempt. And a bench warrant will issue in the amount of 5,000, 10%.
5,000. Woo! That's a lot of money, y'all. That's the most we heard in this case, in this thing so far.
Said 5,000, 10%, Your Honor. Thank you.
Oh, 10%. Okay, 5.
He owes, it would be a $13,000 bond, but I try to give people an opportunity to at least see if they can come up with the amount. So
13,000?
I doubt he can come up with the entirety of that. You may not be able to come up with what I said, but I tried.
Oh, she ended it? It's over with, y'all? Is it over? She ended it. How'd she think gonna end it in the middle of it like that? All right, guys, that was great. You guys here? All right, we're going around the world. So we finished with this world one. Let's go around the world. We're going away to another courthouse. Going to another courthouse. They still have the portion of that Gokenberger, whatever his name is. His case is still on, like, pending. Okay, let's see where Miss Chelsea got us going. Where we going? We're going.
For specialty court today. Ms. Lazar's been here to watch the review. We have a pre-sentence report with recommendations. Have both counsel had a chance to review it?
The people have, Your Honor. Yes, Your Honor.
And additions, deletions, corrections to the factual content.
All right, here we go, y'all. We got another court case.
Mr. Bilbay, do you have a position on sentence today for the people?
Okay, court proceedings is public records, y'all.
Your Honor, at this time, we would ask that you sentence Ms. Lazare into the sobriety court program. I think based on her record of having troubles with alcohol and the very high blood alcohol level that we had in this case, that she clearly has a significant issue with alcohol that needs to be addressed. She is a person who works 2 jobs, both at Target and cleaning at McLaren, keeping herself busy, and she's also obviously providing money to live off of, which I know is also something that's needed for the program. She has started taking AA classes. I think she's kind of in the beginning phases of realizing some of the issues that she's had with alcohol and the needs to make substantial changes. So we would ask the court to enter her into the program at this time, Your Honor.
You don't know where this court is. But we're around the world somewhere.
Ms. Lazare, what would you like to say for your sentence today?
Not much. I'm just needed of this program. I enjoy going to AA. Had a couple slip-ups and
Yeah, we had a problem. Yeah, you've tested positive a couple times between plea and sentence.
yeah, just being around the wrong crowd and just bad influence, people making fun of me for the position I'm in and not realizing I don't need to be around those kind of people. And just the people in the AA group that I met since I've been going, they're amazing people. They're not judgmental, and just being able to, every meeting I go to, try to connect with somebody and get somebody's phone number so we could talk if I need it. and I met a lot of great people, especially someone who is looking to be my sponsor, Megan. It was amazing. I'm supposed to meet with her later on today.
Okay.
And I just enjoy everybody not being judgmental and not me having somewhere to go when I need somewhere to go and people not judging me for what I'm going through right now.
Mm-hmm.
And then like just the slip ups, every time you act out on emotion, you always lose. So just try to stay focused.
Make sure the proposed sponsor has 5 years of sobriety. That's what we require for a sponsor in our program. Yeah, I mean, one thing you're going to have to, I guess, learn is different coping skills, because if you use substances because you're upset, a couple things happen. One, in this program, you can go to jail.
Yeah.
Another is whatever's upset you doesn't go away just because you use. So we have to work on having better coping skills, other ways to deal with the hardships of life, because even if you do the whole program and you're sober, things happen, right? Like life is going to be having things. People get sick, people pass, people get in arguments. You got to come up with another way to deal with all of that. But you really have to engage in treatment so that you can stop using while in the program. Because if you continue to use and you're not able to maintain sobriety in the community, we'll put you in residential treatment to try that. But the first step is to try community-based treatment and see if that's enough to help you abstain from use. But if you still are using, knowing jail's on the line, knowing that, you could potentially be revoked from the program, then it sounds like residential might be the next step for you. So kind of on the line right now between residential and community-based treatment, just because you knew you were being tested, you knew you were on bond, and you still thought using substances was more important to you at that moment, you see?
Yeah.
So we need to get to a different spot. Okay, based on the assessment and obviously the use while on bond, as well as the VAC from that day, it does appear that treatment is necessary and appropriate at this time, and therefore you're appropriate for specialty court. As you well know, you're placed on a delayed sentence for 12 months on the felony. And then if you're doing well after the 12 months, you'll be receive a charge reduction to the misdemeanor, and you'll continue on misdemeanor probation for an additional 12 months.
They're cracking up.
It's important to keep in mind, if you don't comply with the program in that first 12 months, you are risking sentence on a felony charge. And you saw somebody who's in that spot today come into the court. Placed under the supervision of the 54A District Court Probation. Check some of these boxes here. We've got our fingerprints done. Yeah, that's good. While on your delayed sentence and subsequent probation you must follow these orders. Do not violate any law of any unit of government. Do not leave the state without permission. You must abstain from the use of or possession of alcohol, recreational and or medical marijuana or controlled substances without a valid prescription, and from frequenting places where such are sold for consumption on the premises, like bars and nightclubs. You are to maintain some employment verification during your delayed sentence and probation. Make truthful reports to your probation agent as directed. You must appear and make truthful reports at the review hearings as scheduled by the court, including all graduation ceremonies. So as a participant in the program, you do view every graduation ceremony, ending with your own, you hope. And you will be at review hearings every other week, just like you saw this morning. So your review hearing is already scheduled for February 6th, and then every 2 weeks during phase 1.
Thank you, Brian.
Come in, do the review. As you saw the review, I started
Hey, thank you,
in the program
Brian.
longer and work my way to phase 1. So you sort of work your way to the front of the front of the group. So we'll be seeing.
Brian, I'm all over
February
the
6th for your
world.
first review. Let's see.
That's in Michigan, y'all. Michigan again.
Shouldn't I?
Thank you, Brian. Brian, tell
All right.
people that I'm in here. Share this.
You are to attend and complete counseling as directed with verification, and that is intensive outpatient treatment is where we're going to start. That's the community-based treatment that I was speaking to you about. You are to attend 12-step meetings or peer support meetings as directed with verification. That is 3 times weekly during phase 1. You are to submit to preliminary breath tests and urine analysis as directed with a valid sample and pay the fees for that. If you're on the sober tether, you don't have to do the PVTs because you're using the tether, but you still have to do the urine analysis. If you come off the tether, then you would continue with PVTs. You are to complete community service work as directed with verification. There's 30 hours of community service work in this program, but we don't start you working on that really until phase 2 because phase 1 can be a lot. So we don't make you do community service work. Yeah, you can, you just don't have to. You have a question about that?
Yeah, like what is considered community service work?
So it's unpaid work for a nonprofit usually. So some people will do stuff around like the clubs where the AA meetings are held. We have a person who's doing some cleaning at the clubs for verified community service work. Gentleman today said he's working at the Salvation Army Community Food Bank. We had
Coaching any sports or Lansing Parks and Recs considered community service?
you have to talk to your probation agent about it, but probably not. We had someone who was painting the church. The church couldn't afford to pay for painters, so he did painting for free. There's lots of different varieties of community service work. Okay. You must attend the victim impact panel as directed with verification. That's, I believe, due in phase 1. You are to notify your probation officer within 24 hours of any police contact, missed appointments, counseling sessions, missed or positive testing, or any change in employment address or phone number. So you want to shoot your PO and email anytime something like that happens because you want to be the first to tell her. You don't want her to hear it from someone else first and have to ask you about it. So if anything happens, you miss an appointment, you email her. You get stopped by the police, you email her. You miss a test, you email her. So she hears it from you first. Do not drive a motor vehicle unless properly licensed by the Michigan Secretary of State. You are required to keep a daily journal, report any prescription or over-the-counter medication use to your probation agent and testing agency within 48 hours of obtaining the medication, comply with any wage assignment order, and comply with any home visit requirements. Wrap this up. There is a $68 state minimum cost for felonies, $130 crime victim rights fee, $120 cost recovery to the prosecutor's office, $100 fee for your substance abuse assessment, $200 in court costs, $500 in fine, and then the oversight fee of $45 a month times 24 months. That's $1,080 for a grand total of $2,198, which you may pay over the term of your probation. But I know you're here earlier, so you heard me say you're not on this program so I can get money out of you. That's not why you're here. I could do that much easier without the program. So don't worry about this money very much right now. You're in the program to work on your sobriety. And so we're not going to talk about the money you need to pay the court very much. You can complete your probation still owing us money if you're making good faith efforts. You need to do your treatment and testing and focus on that because that's why you're here, to try and get you in a spot where alcohol isn't causing you to come before the court, isn't causing you to make choices that are detrimental to your long-term goals. So it's very important that you focus on the treatment at this point. To make sure Looks like a mobilization is not an issue in this case.
You can ask her, but it changes over time.
I work with McLaren overnight Thursday, so it starts at 10 to 6, and then at Target, I would start either at 6, 7, or 8. And I know I gotta be here every other 2 weeks. I was just seeing if it possible to show up via Zoom, or do I have to show up in physical form?
So participants can do the review hearings in Zoom, so long as you understand that you've got to be on the Zoom, your camera on, sitting and paying attention. We have one participant who's coming in person for a couple of weeks because that's not what was happening. The person was logging in late and they were up walking around and messing around during the review hearing, which is distracting to me and not respectful of the participants nor the purpose of the program. Part of the program and part of the research is that seeing others who've come before you successfully completing the requirements shows you that it is possible to be done and can be encouraging. And so you have to come and watch the review. So for you, yes, you can do Zoom as long as you're doing it appropriately. And as you go through the program, you'll get called sooner and sooner. But because you're just getting sentenced, you will be called sort of towards the end of the review. So it could be kind of a longer, like an hour today, you know. So just plan for that. I know you have to be at work and things, but you're going to have to plan to do your court, and then it'll become less and less burdensome as you get through it. But the beginning is a lot. I mean, being honest. Okay. The next thing that's going to happen is we're going to get you down to probation and set your appointment with Brianna to get your orders, all your referrals, get your treatment started, testing going, you know, everything you need to be doing the program. Do you have questions? Okay. Anything else from the lawyers on this sentence?
No, Your Honor. No, Your Honor.
All right. Thank you. Yeah. Yeah, I got that. I can tell Miss Donnelly is ready because she's.
Are you going to take this decision?
Let's see here. Okay.
Mr. Harris,
All right, Ms. Donnelly, come on up. We'll get you started. I'll have Mr. Dowd out of the breakout room momentarily. All right, on the record in State of Michigan versus Jasmine Dowd, 2500115FY.
Jeffrey Bill on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Jasmine Dowd, who is appearing separately by video from Bingham County Jail.
And you are Jasmine Dowd?
Yes, ma'am.
Thank you. Today's the date for probable cause conference. We do have a preliminary exam scheduled for January 30. Have we decided what we're doing?
Your Honor, at this time, I would like to leave it on for the preliminary exam. I have believe that negotiations will continue on a sentencing agreement with the prosecutor. They haven't offered a reduction, but possibly a sentencing agreement. He's got similar cases and holds in Bingham County and Clayton. So we'll just be leaving on for preliminary exam, no other issues.
All right, Mr. Bilbay, you'll be ready?
I'm sorry. Have I ready?
Will you be ready for preliminary exam?
Oh, yes.
Scheduled?
Yes, Your Honor. I'll
Thank
be ready.
you. All right, Mr. Dowd, you're scheduled for January 30, 10 a.m. That is an in-person proceeding. So if you're in custody, we'll bring you over for in-person. If you're not in custody, you got to make sure you're here so we can get this taken care of, okay?
Yes, ma'am.
All right. Anything else we need to address for Mr. Dowd today?
No, Your Honor.
No. All right, you're all set. Mr. Dowd, I think, I don't know if I need your polycon for someone else. There is a chance, so I'm going to put it in the waiting room and you can let the jailer know that we're all set with you, okay?
Yes, ma'am.
Thank you.
Your Honor, was going to ask about, because Jared Austin is stuck in Judge Simmons.
I'm right here.
Oh, you're right there. Good. You hit. Done. All right, never mind. I didn't know if you can't order anything.
That was so nice of you. Ms. Schroeder, come on up. We're going to try and get started with, I believe, Willis, if we got him. Mr. Willis, turn on your video, please. There we go. All right, and then just try to hold still so that the camera isn't all over the place and we'll get going. On the record in State of Michigan versus Sincere Martell Willis, 2403627FY.
Jeffrey Phillippe on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Willis. I am here in the courtroom. Mr. Willis joins us via the Zoom application.
And are you Sincere Willis on the video?
Yes, Your Honor.
Thank you. Today's the date for probable cause conference. We do have a preliminary exam set for January 30 at 8:30. Have we decided what we're gonna do?
Yes, Your Honor, at this time, the defense would be asking this matter be left on for the preliminary exam date. I have been in conversation with the prosecutor and I need to relay some more about that with those conversations with my clients, but we will be ready to proceed on that day.
So will the people, Your Honor.
Okay. Mr. Willis, your preliminary exam is January 30 at 8:30, and that is in person because evidence and testimony may be presented at that time. So it's very important that you're here in person on January 30 at 8:30. In the meantime, please remember, you must follow your bond. One of your bond conditions is to contact pretrial services. Have you been in touch with them?
All right. Yes, Your Honor.
Okay, make sure you're staying in touch because they'll send a non-compliance report if you don't report as directed. Also, do not leave the state without permission. Do not commit crimes. No alcohol or illegal drugs, no firearms or dangerous weapons, no assaultive behavior. Anything else we need to address for Mr. Willis today?
No, Your Honor.
No, Your Honor.
All right, Mr. Willis, you are all set to leave the meeting. Remember, in person, January 30, 8:30. See you then.
Okay, thank you.
You're welcome. You got Mr. Lake here in person with you as
Yes,
well.
he is.
Okay,
He'll be
come on
ready to go
up,
on that.
Mr. Lake. Calm down. On the record in State of Michigan versus Michael Clarence Lake, 2302742 FY.
Thank you.
Jeffrey Phillippe on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Lake, who is present and is standing to my left.
And you, sir, Michael Lake?
Yes, ma'am.
Thank you. Today's the date for probable cause conference. We have our preliminary exam set for next week, January 30 at 8:30. What is our plan?
At this time, it is, defense wants this to be left on for preliminary exam. I have noted that we have not yet received some video. I will follow up with the prosecutor's office regarding that. It appears from the police report that there's some dash cam and body cam that is still outstanding, it appears. So I will follow up with a formal request. Thank you.
Okay, well, that needs to be done as soon as possible because requests to adjourn generally need to be made at PCC, not PE.
I understand, Your Honor. I will.
Mr. Billive, you got a request in for that video there?
Yes, soon after we receive a formal request, I'll forward it to a discovery.
Shouldn't you be requesting it so that you have it in your possession on behalf of the prosecution?
We could also do that, Your Honor.
Make sure you have it ASAP.
Yes.
It'll be, I don't want to have this conversation again next week. Okay, exam is on for January 30 at 8:30 in person because evidence and testimony may be presented at that time. Mr. Lake, of course, you must continue to follow your bond in the meantime. Have you been in contact with pretrial services?
Yeah.
Okay, make sure you stay in touch however often they told you to so you don't get a non-compliance report. Do not leave the state without permission. Do not commit crimes on bond. No alcohol, marijuana, illegal drugs, no firearms, dangerous weapons, no assaultive behavior. Anything else we need to address for Mr. Lake?
No, Your Honor.
No, Your Honor.
All right, Mr. Lake, you have notice of your court date for next week, or do you need us to print you a new one?
Thank you.
You want a new one? Okay, we'll provide you a new court notice in just a moment, and then you'll be on your way for today.
Sure, we appreciate it.
No problem. All right, over there at the jail, what's your name, sir? I'm sorry, try again.
Benson Walker.
Oh, Mr. Benson Walker, gotcha.
Thank you.
Speak with Mr. Benson Walker.
Okay, but where'd he go?
Gracias.
All right, Mr. Benson Walker, your attorney stepped out for a second. I'm just gonna have to put you in the waiting room for a minute more. Let's see how that goes. Let's see, who else do I have here? Hello, sir at the jail. What's your name?
Thank you.
Mr. Withers, Charles Withers.
Okay. I have an attorney here for you. Just one second. I'll see if he's ready. Mr. Cornish, I think you said you were covering Milks. Mr. Withers is on Milk's docket? Or is Mr. Oh,
Yes, that is Mr. Withers. I apologize. Do you need to speak with him? No, Your Honor, we spoke yesterday at the jail as well as last week. Thank you.
On the record in state of Michigan versus Charles Irwin Withers, 2403684 FY.
Chester Bill on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Withers. I am here in the courtroom. Mr. Withers joins us via the Polycom and Zoom.
Thank you. Today is the date for the probable cause conference. We have a preliminary exam set for next week, January 30, 8:30. Have we decided what we're doing?
Yes, Your Honor, the defense is going to be having that, requesting that be left on. There has been an offer relayed at this time. However, I don't know if that's going to resolve in terms of us not having agreement. So we would ask that be left on. Thank you.
Spillbay, you'll be ready?
I'll be ready, Your Honor.
Thank you. Okay, Mr. Withers, preliminary exam, January 30, 8:30. That is in person, as evidence and testimony may be presented at that time. So if you're in custody, we'll bring you over. If you're not in custody, make sure that you make your way to the court and that you're here January 30 at 8:30 so we can get started. In the meantime, remember, if you do postpone, that you need to report to pretrial services. Is someone trying to get your attention?
Yeah, I don't know what they're doing. That was crazy.
Okay,
Yeah.
well, we'll be done in just a moment here. If they're trying to get that Polycom back, we'll be done in just a minute. Okay. If you do get out of jail, I don't know what your circumstances are, but be sure you report to pretrial services and then contact your lawyer so that she knows you're out and can make sure you're ready for your hearing, okay?
Yes, ma'am.
All right, anything else we need to address for Mr. Withers?
Nothing from the people.
Your Honor, I will note he is serving a sentence. He's not due to be out until April, so he would need to be brought from jail next week, but nothing.
Okay, we'll make sure he's brought over for our hearing.
All right, thank you.
All right, Mr. Withers, you're all set. You can let the jail know that you're done with that Polycom and they can let someone else use it if that's what their problem is.
All right, thank you.
You're welcome.
Thank you. Thank you, Your Honor.
All right, let's see if I can figure out which one this is. Hello, sir, what's your name?
Evan Silvis.
Thank you.
All right, Mr. Silvis, gotcha. I don't see Mr. Freeman yet. Yeah,
Cornish is ready on Aaron White and Dexter Wicks.
yeah, we'll get there in just a second. Mr. Silvis, I'm just gonna rename you so I remember who's in this room. And then when your attorney turns up, we'll get started, but he has stepped out for the moment, so we'll be back with you.
Yes, Your Honor.
All right, well, that stinks. Okay, Mr. Cornish. You're ready with Mr. White?
Yes, Your Honor.
How far down my file is? I have so many files today. On the record in state of Michigan versus Aaron Thomas White, 2500088FY.
Jeffrey Bill on behalf of the people.
Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornish on behalf of Mr. White, covering for Mr. Sarts today, who will remain the attorney of record.
And you are Aaron White.
Yes, ma'am.
Today is the date for probable cause conference. We do have a preliminary exam set for next week, January 30 at 9 a.m. Have we decided what we're doing?
Thank you, Your Honor. We've met with the client. Mr. Sarts has expressed offers. We've gotten discovery and talked to him. However, he would like to have his preliminary exam, so we'd ask this be left on.
Bill Bay, you be ready?
Yes, Your Honor.
All right, we'll leave this on for preliminary exam. This will be in person, January 30, 9 a.m. As evidence and testimony may be presented at that time. Remember, Mr. White, to continue to follow your bond in the meantime. Have you been in touch with pretrial services?
Yes, ma'am.
Make sure you stay in touch as often as they've told you to, because you don't want them to send a non-compliance report.
Yes, ma'am.
All right, do not leave the state without permission, do not commit crimes while on bond, no alcohol, marijuana, illegal drugs, no firearms, no dangerous weapons, no assaultive behavior. And then there's a no contact order for Mr. Lowe. You're not to any direct contact, indirect contact, not to be within 2,000 feet of where he lives, works, or goes to school. And you should have a GPS tether that will alert law enforcement if you violate that order. Is that right?
Yes, Your Honor.
You should understand this order is about you, it's not about him. I don't know what's going on with you and Mr. Lowe, but if he were texting you or calling you, he can do that. But if you text him back or you take his call, you're the one who risks going to jail. He does not have authority to give you permission to violate this court order because it is the court's order, not his order. So if he invites you to meet up with him and you go, you'd still be risking jail. Understand?
Yes, Your Honor.
All right, do you have your court date for next week already, or do you need it printed again?
I have it. Your Honor.
Okay. All right, we can print more copies whenever you like, so you good?
I'll take one.
All right, we'll print a copy of that right now for you. Anything else for the record from the lawyers?
No, Your Honor. Nothing for the defense. Thank you, Your
All
Honor.
right, thank you. You're all set. I haven't seen Miss Lange yet either, and she was supposed to have.
Yeah, for Baker, Robert Baker.
Yes.
I'm gonna cover that for her. She had to be pulled away for another hearing.
Okay, well, let me do Carter, and Carter, do you need to talk to Watchmaker before we start?
No.
Okay, Mr. Watchmaker, turn on your video and we'll get started.
Is it on?
It is. On the record in state of Michigan versus Samuel Donald Watchmaker, 2500044 FY.
Jeffrey Billabell on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Watchmaker, who is appearing through the Zoom app, and we have no objection to holding this hearing through that media.
And you are Samuel Watchmaker on the video?
Yes, ma'am.
Thank you. Today is the date scheduled for probable cause conference. We have a preliminary exam set for next week. Mr. Carter, have we decided what we're doing about that?
We'll be running the preliminary exam.
Mr. Bilbay, you'll be ready?
Yes, Your Honor.
All right, we'll leave this on for preliminary exam next week. That's January 30, 9 a.m. in person. Mr. Watchmaker, it's very important that you understand that's in person, as evidence and testimony may be presented at that time.
Yes, Your Honor.
In the meantime, continue to follow your bond. Have you been reporting to pretrial services?
Yes.
Okay, make sure you keep doing that as often as they tell you to. Do not leave the state without permission. Do not commit crimes on bond. Do not possess or consume alcohol, marijuana, illegal drugs, no firearms, no dangerous weapons, no assaultive behavior, and no contact with Ms. Bolko. You're not to have any direct contact, no indirect contact. You're not to be within 2,000 feet of where she lives, works, or goes to school. You should be wearing a GPS tether, which will alert law enforcement if you violate that no contact. You understand that?
Yes.
All right. Also important to understand, this order is about you. It's not about her. So if she's texting or calling you, she can do that. But if you text her back or call her back, you're the one who risks going to jail. She does not have authority to give you permission to violate the order because it is the court's order. So if she were to do those, invite you to meet up with her and you went, you'd still go to jail. Understand?
Yes.
All right. Anything else we need to address for Mr. Watchmaker today?
No, Your Honor.
No, Your Honor.
All right, Mr. Watchmaker, I'll see you in person January 30 at 9 a.m. Follow your bond.
Yes, Your Honor.
You may click leave. Hello, sir, at the jail. What's your name?
Robert Baker, Your Honor.
Okay. All right. Thank you. On the record in state of Michigan versus Robert Charles Baker II, 2500119 FY.
Jeffrey Billabell on behalf of the people.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder, covering for Attorney of Record, Attorney Melanie Wanji for Mr. Baker.
Thank you. And you said you are Mr. Baker on the video, is that right?
That's correct, Your Honor.
All right. Today is the day for probable cause conference. The preliminary exam is set for next week. Have we decided what we're doing?
My understanding from Ms. Wanji is that this matter is going to be left on for preliminary exam. Thank you.
I'm sorry, Your Honor, I could not hear that.
She said that from talking to your lawyer, she's just standing in for the lawyer. They're in the same office, that you're going to leave this on for exam next week.
That I'm going to leave what?
You're going to have a preliminary exam next week.
Yeah, thank you,
Yeah?
Your Honor.
Okay, did you talk to Ms. Wanji, your lawyer?
She came briefly for a couple minutes over the Zoom and just said she'd have to make another appointment, come back. That she wasn't able to talk for very long, literally minutes.
Okay,
If from what I'm seeing in our system, it appears that Ms. Wanji spoke with him yesterday at a Polycom visit with him. At least that's what the system indicates.
sure. He's saying the Polycom visit was very, very short, but she said she had another appointment and left the Polycom after a few moments.
I do not know.
Well, I guess I don't know if you have a few moments to touch base with Mr. Baker right now in case he has questions or things for council that haven't been addressed yet.
I can speak with him. I don't know how much I can give him in terms of information.
Thank you, Your Honor.
Okay, Ms. Schroeder, if you can talk to him, he might have questions that you can at least try to talk about procedure, things that he might have
Yes,
questions. Okay, I appreciate it.
Yep.
Mr. Baker, I'm gonna send your Polycom to a private room. Ms. Schroeder is gonna join you in there in a minute so that you can ask her some questions. Okay, I'm gonna hold on to that file in case we have to go back on the record. All right, Mr. Cornish, you said you had another in person?
Yeah, sure. I got Mr. Dexter Wicks here.
Okay. Come on up. On the record, State of Michigan versus Robin Sue Dexter Wicks, 2500095 FY.
Yes, Bill, on behalf of the people.
Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornish, on behalf of Ms. Dexter Wicks, who's in the court and standing to my left. I'm covering for Mr. Attorney Sartz, who will be the attorney of record.
And you are Robin Dexter Wicks?
Yes, ma'am.
Thank you. Today's the date for our probable cause conference. We have a preliminary examination set for next week. How are we going to proceed?
Thank you, Your Honor. The defense has received a discovery and met with Ms. Dexter Wicks. We'd like to leave this matter set for exam next week. I believe there was an offer extended and she would like to have her exam.
Okay. And Mr. Villabay, you'll be ready?
The people will be ready.
All right. Ms. Dexter Wicks, your preliminary exam is set for January 30 at 9:30. And that's of course in person, as evidence and testimony may be presented at that time. It's important that you continue to follow your bond in the meantime. Have you contacted pretrial services?
Yes, ma'am.
Okay, make sure you stay in touch as often as they tell you to. Don't leave the state without permission. Do not commit crimes on bond. And then we also have an order for no alcohol, marijuana, illegal drugs, no assaultive behavior, no firearms, dangerous weapons, no contact with Mr. Wicks, no direct contact, no indirect contact, not to be within 2,000 feet of where he lives, works, or goes to school. And you have a GPS tether that will alert law enforcement if you violate that order. It's important to understand this order is about you, it's not about him. So if he's texting or calling you, that if you text him back or you take that call, you're the one who risks jail. He doesn't have authority to give you permission to violate this order because it's the court's order, not his order. So if he invites you to meet up and you go, you still risk jail. Understand? Okay. Do you have your court notice for next week or would you like us to print you a new one?
I have one.
Okay. You have your notice, then counsel, anything else for Ms. Dexter Wicks?
No, Your Honor.
Nothing from the defense. Thank you, Your Honor.
I'll see you next week then. Austin's back. Mr. Benson Walker's waiting.
Mr. Austin's also ready on ask a judge.
Yeah, Mr. Austin, let's start with Mr. Benson Walker.
Okay.
Come on up. On the record in state of Michigan versus Tyrone Benson Walker,
Ooh,
500058 FY.
Good luck.
Jeffrey Bill Bay,
Dexter.
on behalf of the people. And thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Benson Walker. He appears with us remotely from the Ingham County Jail.
And sir, you did say that you are Tyrone Benson Walker?
Yes, ma'am.
Thank you. Today is the date scheduled for a probable cause conference. We have our preliminary exam set for January 30 at 8:30. Have we decided how we're going to proceed?
Yes, Your Honor. At this time, we would just ask that the matter continue on as scheduled.
Mr. Bilbay, you be ready?
Yes, Your Honor.
Okay. Mr. Benson Walker, your preliminary exam is set for January 30 at 8:30, and that is in person, as evidence and testimony may be presented at that time. It is important that you are here in person for that hearing. So if you're in custody, we'll bring you over. If you post bond, then you need to make sure that you're here in person at 8:30 sharp that day. In the meantime, of course, you have this no contact order. That applies whether you're in jail or you're out of jail. No
contact with Ms. Shadwick whatsoever. If you violate that order of no contact, if you're out of jail, you could be arrested without a warrant. Any bond you posted could be revoked. Whether you're in jail or out of jail, you could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines. And that is consecutive to that which you already face. You should also know if you're making those calls from in jail, you could lose your phone privileges. The prosecutor can listen to those calls. They can use those calls against you. They can use those calls to add additional felony criminal charges. So be sure you're following that court order.
Yes,
Anything
ma'am.
else yeah, thank you. Anything else we should address for Mr. Benson Walker today?
No, Your Honor. I have nothing additional at this time, Your Honor. Thank you.
Okay, Mr. Benson Walker, we'll be seeing you on January 30 at 8:30. You are all set. I'm just gonna put your call into the waiting room because I have to use the polycom for someone else. So we haven't seen Freeman yet or Mr. Silvis. This, okay, Mr. Scotia. On the record, State of Michigan versus Paul Escocia, 2500087 FY.
Jeffrey Philip on behalf of the people. Yes, thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Escochea. He stands present to my left.
Is that how you say it, Escochea?
That's how it's pronounced.
I think we've had 3 different people with a similar spelling of the last name there, and everyone says it differently.
Escochea.
Escochea, gotcha.
Yeah.
All right. I'll try to remember.
Sorry.
I'm telling you, one of your relatives out there probably taught me to say it differently. All right, today's the date for probable cause conference, and we have a preliminary exam set for next week on January 30 at 9 a.m. Have we decided what we're doing?
Yes, Your Honor, we would ask that the matter be continued as scheduled.
Mr. Bilbay, you'll be ready?
The people will be ready.
All right. Leave this on for preliminary exam, January 30 at 9 a.m. That's in person because evidence and testimony might be presented that day. In the meantime, you have to continue to follow your bond. Have you been in contact with Procedural services?
I have not.
Okay, can you give them that brochure there, Mr. Austin, that yellow one? You need to call that number or go there, one or the other, but make sure, because you don't want them to send us a non-compliance report.
Okay.
Do not leave the state without permission. Do not violate any law of any unit of government. You must not possess or consume alcohol, marijuana, illegal drugs, no firearms, no dangerous weapons while on that. Do you have your court notice for next week, or would you like us to print you a new one?
I'll take one.
You'll take one. We'll print you a new notice right now and make sure you know when to be back. Anything else we need to address for Mr. Escochea?
No, Your Honor.
No, Your Honor, thank you.
We'll have that for you in just a minute. Oh, Mr. Freeman's here.
Thank you, Your
Honor. Okay, so I still need to use that post 2 and post 1 visit 3. Are you still Mr. Benson Walker?
Yes, ma'am. I didn't know if I was there yet.
I do believe you're all set, sir. Have a good day.
Thank you.
Should be empty. Oh, there's 5. Bring it.
Thank you very
You're welcome. Mr. Freeman, are you going to need to speak to Mr. Silvis?
I will not need to, Your Honor. Thank you.
Mr. Freeman, whenever you're ready, we have him up on the video.
Not much. How are you?
Okay, on the record, in state of Michigan versus Evan Mitchell Silvis, 2403759 FY.
Jeffrey Billable on behalf of the people.
Stephen A. Freeman, Assistant Public Defender on behalf of Mr. Silvis, who joins us via Zoom.
And you, sir, you are Evan Silvis on the video.
Yes, Your Honor.
Thank you. Today's the date for our probable cause conference. We have a preliminary exam set to occur next week. It's on January 30 at 10 a.m. Have we decided what we're doing about that hearing?
The defense would like to go forward with the exam as scheduled. That would please the court.
Okay. Mr. Billabay, you ready?
I'll be ready, Your Honor.
Okay, we will leave this on for preliminary exam. That's January 30 at 10 a.m. Mr. Silvis, that is an in-person hearing because evidence and witnesses may be presented at that time. So if you're in custody, we'll bring you over. If you're not in custody, make sure you present yourself to the court in person on January 30 at 10 a.m. Also remember that, thank you. Also remember you have this no contact order with Ms. Stevens and Mr. Henley. That applies while you're in jail or you're out of jail. If you're out of jail, you could be arrested without a warrant and any bond you posted could be revoked. Whether you're in jail or out of jail, if you have contact, you could be in contempt of court, for which you face up to 93 days in jail and or 7,500 in fines consecutive to that which you already face. You should also note that if you're in jail, they're listening to your phone calls. You could lose your phone privileges. They could use your calls against you. They could use your calls to issue additional felony criminal charges. So it's very important that you follow that no contact order while you're in jail or if you're out of jail. Understand?
Yes, Your Honor.
All right. Anything else we need to address for Mr. Silvis today?
Thank you, Your Honor. Oh, I'm sorry. If I could just tell Mr. Silvis, I'll be out. You and I are gonna visit Monday afternoon after lunch, Mr. Silvis, okay? Monday after lunch.
Okay.
Thank you. Yes, sir.
Okay, you're all set for today. I will be seeing you next week.
You just step on me.
No, that's.
Yes, Your Honor.
We know, is anyone on here? Nope. And I don't think I need that Polycom right now. Waiting for post. One visit 3.
It's not broken,
Okay,
just like you gave it.
okay.
Thank you, Judge.
Well, Mr. Cornish stepped out. I was gonna ask him about the denial of Schmidt.
No, he denied.
Oh, he said no, thank you?
Yes.
Oh, boy.
Yeah.
He must be optimistic.
Yeah.
Hmm. Okay.
He'll be calling from the DOC.
Yeah. Yeah.
Mr. Baker.
Oh, Ms. Schroeder, are we all set with Mr. Baker, or do we need to go back on the record?
No, we're fine, Your Honor. Thank you.
Okay. All right, Mr. Baker, I believe you're all set now. We'll see you next week on the 30th.
Okay, Your Honor, so I've been, show cause on a single charge of,
So on the 30th, we're gonna have a preliminary exam on the single charge of possession with intent to deliver under 50 grams. So that's what we're gonna be doing next week. You're all set for today, okay?
thank you, Your Honor.
You're welcome. You can let the jailer know that you're done with that Polycom device and someone else can use that room.
Thank you, John.
You're welcome. Hope they switch them out because that's where screen's supposed to be. Okay. So we'll see. Any signs of Billy King yet? I know it's early.
Not yet, Judge.
No? We'll see. Everyone gets 15 minutes. Covering type Taylor. Okay, good to know because I hate Cormac right now.
I'm sorry. I didn't mean to throw you on. I really didn't. Yeah, I should have. I just, I apologize. I hate how I did it.
He's still there, still waiting for them. They fed him lunch in the room, but we need the room. He's eating lunch. Yeah, I saw Mr. Nagel bring it to you.
Yeah.
I'm disappointed that we lost it.
What's that?
I said, I'm disappointed we lost it.
I know.
What the heck?
I don't know what the heck. I don't know.
Actually, with as many files as go through here, sometimes I'm amazed we don't lose more.
Right. Yeah.
A lot of papers.
Yeah.
A lot of papers.
I apologize for that.
That's me.
Now you're making you feel bad.
No, I'm the one who feels bad here. Nah, I got you. It was poor timing. And, you know, that's not how I usually roll. That's why, yeah, fair enough. Yeah, I got you. No worries.
Okay.
And I felt, like I said, don't you feel guilty about it. I'm the one who kind of had a little poor energy there.
We're trying to decide whether to check the polycom again or call the jail, because I'm like.
All right, y'all, this is boring right now.
Yeah, well, yeah, right, like.
So we're gonna move over to another court.
Yeah. We got all my work done today. So much work.
We're going around the world, y'all. Let's go find another court.
That's the same person. How much you want to bet?
There's no way of knowing that. There's no way of knowing that.
I know,
Hmm?
but I'm gonna say.
Okay, let's swap her.
This is Mr. King. All right, are we ready when I can find the building?
I will be
All right, let's go to the next court. Hold on, y'all. We're going to another court. We're going to Judge Cedric's court. Cedric Simpson, the judge for the landlord court.
Thank you, sir. Where'd Burgess go?
Well, he's not doing landlord today. He's doing actual criminal cases. Okay.
Maybe in custody, Your Honor.
Huh?
He may have been speaking with another client in custody.
It's possible he didn't realize we were calling it because we did this. So. Mr. Burgess knows this is being called.
You don't see him? We're gonna check lockup real quick. Thanks, Mr. Jerkus. Bye.
Attorney will be back.
Yes, sir.
I was in the lockup, sorry, Your Honor.
All right. I called the case.
All right, good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Marcel Steeper.
All right, these were set for preliminary examination. My understanding is he wasn't available to go today.
It was because of the cold day and everything got backed up, Judge, and the officer, I guess, was only available for a short amount of time today. They were not able to proceed today. So we picked the February 4th, I believe.
Yes, this was in front of Judge Moore, so when I contacted your office, asked for an adjournment, I was directed to Judge Moore's office, who approved the February 4th exam date in front of Judge Perry. And Judge Perry as well.
Got it.
Order with this case as well as the chief of defense, et cetera, et cetera.
Sure. That's the 4th, correct?
Yes.
Preliminary examination in person, February 4th, 2025, 9 a.m. before Judge Perry. Bond will continue.
Okay, all right. I'll be right back.
All right. Is that all you had, sir?
No, Judge, but I had to let the court know.
They ready for me? Who's on this one? Yes. Are they ready to? That guy's not looking, they're not, I can't tell. Woods, ready? Court does call the case of the people versus Woods.
Edward Drukas on behalf of the department.
Woods. Thank you. This is the same co-defendant. So preliminary examination in person, February 4th, 2025, 9 a.m. before Judge Perry. Bond continued.
Thank you, Your Honor.
So I never went in and do it. She wasn't around.
Court calls case of the people versus Malik Word.
Good afternoon, Your Honor. Sam Bernstein with on behalf of Mr. Ward.
Malik Word. All right. This, like the other one's going to be adjourned to the 4th. Preliminary examination in person, February 4th, 2025, 9 a.m. That is before Judge Perry. Bond will continue. Thank you. Court does call the case. Oh, gotta wait. Court does call the case of people versus Melvin Reeves. Can you,
Nicole, you on behalf of the people.
Stephanie Cannon with the Public Defender Office on behalf of Mr. Reeves. Mr. Reeves, can you state your name for the record?
Tyrone Reeves. Thank you.
Your Honor, since the date and time scheduled for exam, this kind of people are not able to proceed on count 1 and count 2, and I would motion to remand on the misdemeanor count 3.
Counts 1 and 2 are dismissed, people being unable to proceed. Set a pretrial date on count 3 before Judge Washington You have a date?
February 24th.
February 24th, 2025. I'm sorry, 10 a.m.
Yes.
10 a.m. before Judge Washington.
Your Honor, I'd like to address bond.
Yes.
Your Honor, at this time, we would ask my client be allowed to be released. He has a home. The complaining witness in this case does not live there. He has no intentions on seeing her or speaking with her. He is asking to be released to his home at this time, Your Honor.
Where's his home?
This, the 302 address, Your Honor, 302 Bridge Road.
I don't have that as an address. I have Villa Drive.
What's the name of the apartment?
It's Bridge Road Apartment,
He's saying it's Bridge Road Apartments, Your Honor, is where he lives.
5800 Bridge Road, 302, apartment 302.
This incident was, the alleged incident was at her place of residency, not his.
Okay, that's fine, except that
Yes, Your Honor.
you saying the villa is her address?
Yes, Your Honor.
Right now.
Well, that's obviously the address he was using because now the events occurred at Spinnaker Way.
Okay.
He has a Villa Drive address.
You have a, are you no longer residing here?
No.
He said that is not his address, Your Honor. He's not sure why the court has that information. He said he does not remember that ever being his address.
Yes.
Is he otherwise going to post his $10,000 bond that's holding him until February 7th?
Yes.
He's not going to post that bond. I don't know why we're doing this, sorry. He also has an out-of-county hold from Allen.
Right?
Does he? Okay.
Bridge Road.
But otherwise, it's
GG.
regardless of this case.
Is that correct, counsel?
Yes, Your Honor, but my client has
Well,
indicated that
then why am I using an argument on this?
he's,
He'll actually see what court is he before on the 27th? Where is that? What court is that out of?
14B.
So he's actually gonna see Judge Washington before the, I don't know why am I hearing this argument?
This for the same.
okay.
Well, I'll solve it.
I'm
Motion
sorry,
for
Your
bond
Honor, he
reduction
is-
denied.
I'll come and see. We'll talk about it.
Phone.
Yep. Your Honor, my client wants to know if he can get his phone privileges back since this case.
Phone privileges will remain revoked. Court calls case, People versus Sean Caldwell.
Andrew Childers appearing on behalf of the people.
Good afternoon again, Your Honor. May it please this honorable court, David Burgess, on behalf of Sean Caldwell. Your Honor, there's going to be a waiver as to count 4. I believe counts 1 through 3 are being dismissed per the people.
That's correct, Your Honor. In return for a waiver as to count 4, the people would be dismissing counts 1 and 2.
And Your Honor, my client has been informed of the offer today, has been informed of his right to preliminary examine this matter, is choosing to voluntarily waive his exam and have his case bound over to circuit court for further proceedings on count 4 only.
Counsel approach.
This judge is being mean today, y'all. He's being real mean.
Sir, is that correct? You're waiving your right to a preliminary examination on count 4?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right as second.
Yes, Your Honor.
Preliminary examination is waived as to count 4.
Waive any further reading, stand mute to the charge contained.
Defendant have waive for reading standing mute. Court will enter a not guilty plea. Pretrial will be set for February 5th, you said?
Yes.
2025, 1:30 before Judge Conlon.
See what we can do about that.
Bond will continue.
Thank you, Judge.
No.
This is the last
I know what those files are.
No, I know, I'm just like, I don't have anything to give you after this. It's call.
Court does call the case, People versus Paul Walker.
Andrew Childers appearing on behalf of people.
It's you guys.
Yeah.
They're rolling.
Mr. What's that? Brian. Where's Brian?
They went to go get him. Is he in lockup? You think he's in lockup? Talk to him.
Who? Mr. Bowling's in lockup? Tell him to get here unless he'd like to stay. Your name, sir?
Yeah, my name's Paul.
Walker?
Yeah.
Okay.
So Paul, what did you and Brian talk about during here? Yeah, I really want to kind of just,
Hold on, I'm just waiting for.
Sorry, Your Honor. Brian Bowling on behalf of Mr. Walker. Your Honor, in this matter, I think it would be appropriate to refer Mr. Walker for a criminal responsibility evaluation based on my review of some of the facts and circumstances of this case. Further discussions with brother counsel in the prosecutor's office. I think that would be appropriate for a determination to be made by professionals regarding his criminal responsibility at the time of the offense. That's what I'm moving for at this time.
Okay, you understand that wouldn't be dealt with at the district court level in any event.
I understand.
I'm sorry, Your Honor. If I may, I've spoken to Mr. Bowling a lot. I spent some time with the victim in this case this morning and her family members. Without getting into too many of the details, the facts of this case are peculiar.
Very.
And I think having that sort of report done could be very helpful in determining an ultimate disposition of this case. I suspect that Mr. Walker struggles with mental health issues based just purely on the reading of the police report. And the victim in this case was actually a nurse at the hospital, kind of agreed with that assessment.
Okay. All right. So what were you intending for me to do with the case, though? Because I can certainly do the criminal responsibility referral, but those are even further behind than the competency referral.
I guess I would ask for a brief adjournment of the exam date. But understanding is at least I could submit the order with the understanding that it may be a while till that occurs.
Was this mine or hers?
It's worse.
Mine.
Yeah.
Well, here's what I'll do in case you want to go. I'll adjourn the preliminary exam date, but I'll adjourn it to the 11th. 2025 at 9. That's before me, but if there's going to be an order, then get the order to me as soon as possible so that we can get it moving along. It's just not going to be quick. That's my only issue.
I understand, Your Honor. You'll have it by the end of the day.
I will continue.
Thank you.
Thank you. Here after day. Okay, so in the back row, they have a woman sitting in the very back. That's on that case. They're on me. I don't see everybody else is quick, otherwise I'm gonna.
Sydney is still in lockup with Mr. Ali. This is going, but it's not right.
There's no rushing right there. This is gonna be a while. Let's get it.
Waivers, yeah, I'll be waiting.
All right, they got it muted right now, y'all. All right, this is getting a little bit boring right now.
What do you have at this cabinet?
I have two.
No, I got it. 1, 4, 5, 6.
If you can remember it on the camera. There's one.
What? Court does call the case of the people versus Desmond Ali.
Good afternoon, Your Honor, Shalani, good people.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Mr. Ali, who is approaching to my right. Restate your name for the record, please.
Desmond Ali.
Thank you.
Your
It's gonna be, go ahead. No, go ahead.
Thank you. We are set today for a preliminary examination of this case. If you understand, the defendant is going to waive condition upon an offer that people have made, where upon a plea in circuit court to counts 1, 2, and 4, which is carrying concealed weapon,
Go ahead.
felon in possession of a firearm, or prohibited person in possession of a firearm, and count 4, resisting or obstructing a police officer, count 3, felony firearm will be dismissed in circuit court. There is no promise about habitual. Habituals will likely still be filed, and he will need to figure those out in circuit court, but that is what he's waiting for today.
The numbers we use should be the numbers on the complaint.
All right, guys, we're gonna move over to another court because it seems like they're very boring.
You think so?
Yeah, let me double check, but that should be.
All right.
There's been an altercation in the past where police were called, but no arrest was made.
This is
She said she's okay with no violent contact, but she's unsure about returning to the residence, Your Honor, just based on the facts. This is a situation where no contact is what's appropriate, and that's what we'll be asking for. If you'd sound for Mrs. Carney. Thank you.
All right, is Ms. Carney present? I want you to make a brief statement. I don't see anyone with that name. Mr. Rogowski, is this your client?
This
is my client, Your Honor.
Any
I
objection to that SOB through pretrial level 1, no contact, and a 1-day anger course?
No objection to that, Your Honor. My concern, however, is the address that was relayed to me by Ms. Dillon is on that Mescalin Street address. So I don't know if she does have somewhere else to stay. Ms. Dillon, if you could give me a thumbs up, if you could stay with a family member or a parent in the meantime.
Look at Patricia's eyes, y'all.
I'm a reporter. I pay all the bills. I don't understand that. But I definitely have somewhere to go.
All right. For the time being, if what we'll do is we'll do a one-time law enforcement escort. If Miss Carney is there, she should stay away. I think there needs to be a little bit more of a cooling off period. If she's not there, she can return to that location. Defendant's going to receive a $3,000 SOB through pretrial at level 1. It's $1,500 on each count. She's have no contact with the alleged victim again. Stay away from that location if the victim resides there. We'll make that determination with LEO. She's have no alcohol, no drugs, no weapons, and she's going to take the 1-day anger awareness course as well. And again, bond can be addressed and reamended at a later date on motion. All right, best of luck to you, Ms. Dillon. That concludes your case. Who do we have next?
Position number 8, Evans.
All right, are you Priscilla Evans?
Yes, ma'am.
All right, Ms. Evans, your case is 25 CR 00380. J, in this case, you're charged with battery, family violence. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Howard?
19 on probation out of Greene County, ag assault, 2024 battery arrest, 2024 parole, 2023 parole, 2023 false report of a crime conviction, 2014 another ag assault conviction, and a 2014 criminal attempt to commit a felony, possession of tools conviction. That's
Okay, thank you. Ms. Mokake, please proceed.
Yes, Your Honor. And just to add, she also has an aggravated battery conviction that's a little older. It's from 2001, but it does demonstrate that she has a pretty violent history. This incident happened at 1331 Jonesboro Road, Southeast in Atlanta. The victim in this case is Kenneth E. Austin. The parties were having a verbal dispute that turned physical when the defendant bit the victim's hand, leaving bite marks on his hand. The victim told officers that he was in fear for his life after this, and he did flee the location. The parties had been dating for about a year when this incident occurred, and they'd been living together for about a month. Given the defendant's history and the facts of this case, the state's recommendation is a $1,500 surety bond, no further contact with Kenneth E. Austin. Stay away from that incident location so long as Mr. Austin is living there. No drugs, weapons, or alcohol while out on bond, and that she also undergo an anger awareness class. I would ask the court to sound for Mr. Austin at this time.
Is Mr. Austin present and wishes to make a brief statement? Okay, I don't see that name. I've sounded twice. Who represents this defendant? Is that you, Mr. McLean? If you're speaking, we're muted. We can't hear you. Is number 8?
I was looking at my stop video. It was on. Thank you, Your Honor. We noted that she had a conflict in her case in October with the public defender's office. We figured she probably still did. Is Miss Maureen McLeod?
Miss McLeod is not on the line.
I think it would see if she's going to represent her. My understanding was she was going to appear at 2, and I'll give her a call.
Ms. Champion or Mr. McLean, can we see if Ms. McLeod will be logging on? If not, let's hold for this position. I'll make note. So Ms. McCocket, well, you'll probably have to go through it again, though, if Ms. McLeod logs on. Okay, so we're gonna come back to this position and note it as a conflict. All right, who do we have next? If no conflict, attorney, it can appear today, we'll still set bond.
ACDC can go ahead.
All right, who do we have? Has ACDC heard their rights?
Yes, Judge.
Good afternoon.
Good afternoon, Judge. This is going to be position number 3. Ms.
She's too short. You can't even see her.
Position 3, Miss
Linda
Block. Okay, yes. All right,
Thank
Ms. Block, your case is 25 CR 000384C. In this case, you're charged with disorderly conduct, false report of a crime, and criminal trespass. You understand your rights today? Is that a yes?
Yeah. Yeah.
Okay. All right, thank you. This is first arrest. So we'll go to you, Ms. Allen.
Thank you, Your Honor. Although this is the first time this young woman has been arrested, this is the second time police have been called to the location for a similar incident. The location is 515 Centennial Olympic Park. Police were called there in June. It sounds like this defendant shares a boyfriend with another young woman, the victim in this case, actually, Kamaya Rucker. So in June, police were called to that location where they met with the boyfriend in common, Jakari. The defendant was seen there at the location. She'd pepper sprayed someone, refused to leave, seemed to be having some kind of an episode. And Jakari was reluctant to provide information and said she was going through a lot at that time. Yesterday on the 22nd, Your Honor, at about 11:30 in the morning, the defendant in front of you made a call to 911 and said that there were males outside there with weapons trying to kill her. Obviously, police responded to a weapons call using lots of resources and staff to address a dangerous situation.
False police
on
report.
scene. They were flagged down by the defendant. They then recognized that the 911 call about a crime being perpetuated on her by men with guns was actually a false report. Police met with off-duty officers who are courtesy officers there at the location. They reported that this defendant has a problem coming to the location and what they termed stalking this gentleman, Jakari. They spoke to the victim in this case specifically, Mrs. Rucker. She reported that the defendant arrived at the location. She heard the window open. She heard a ruckus, and she heard the defendant screaming, "Where's Jakari? Where's that bitch?" And the victim went outside to let the defendant know she needed to leave. She was still on scene when police made contact. There was also a witness present who reported that they knew about the prior incident in June, and had witnessed the incident today there at the location and watched the defendant open a window to the unit there. I think the specific unit is 105. So boyfriend or ex-boyfriend of these two women lives there. And the young woman in front of you evidently wanted to come and confront him about something, but has been to that location on numerous occasions and has been told, I think, not to come back. So in addition to that, she caused a lot of resources to be unavailable to others who might need it because she reported a crime being committed against her that was not true. I've listened to the 911 call, Your Honor, and corroborated the information I just shared with you. On the scene, when police did speak to the defendant, she said she went to the location looking for her boyfriend, Jakari. And she claimed that his girlfriend came outside and threatened to shoot her. None of the other people on scene corroborated that information. And what was actually discovered is that the young woman had called and made a false report of a crime. We spoke to the victim, the other young woman, Mrs. Rucker. We have not spoken to Jakari, although it's clear that he and the defendant are still in communication based on jail calls. And I believe Mrs. Rucker's on the line, Your Honor, on Zoom. Mrs. Rucker said that she and the defendant did date the same man at a period of time, that the residence is his location. His name is Jakari. She heard something downstairs. She corroborated what happened. She said she heard the defendant yelling, "Where's that bitch?" talking about her and talking about Jakari. She said she actually didn't call the police. It was the defendant who called the police, which is what we now know as well. She also reported about the prior incident, that the door had been busted in June, and the defendant had started pepper spraying individuals, including a child who had to have medical care as a result. So we're asking for a $6,000 surety, Your Honor, no contact whatsoever with either Jakari or Kamaya Rucker. It's Kamiyah. I can get you Jakari's last name. Stay away from that location. I do see an eviction process, maybe even 2 in place against this defendant for where she lives nearby. Stay away from that location. Obviously, no drugs, alcohol, or weapons. And we'd ask for a social worker visit, Your Honor, or some kind of evaluation. And if you could call for Ms. Rucker.
Okay. I'll look at one thing before I do that. Okay. Ms. Rucker, if you would like to make a brief statement, please raise your right hand. You and unmute. Do you swear or affirm the testimony you give today be true to the best of your knowledge? You're muted. Please unmute quickly.
Why are they done?
Yes, can you hear me? Yes. All right. Again, this is a bond hearing. Defendant is entitled to a bond as this is a misdemeanor offense. If you want to add to the facts, that's not what I'm concerned with. I'm most concerned with any concerns for your safety and whether you wish to have contact. What would you like to tell me?
Yes, I'm very concerned for my safety and I want no contact at all.
Okay.
And Your Honor, Mr. Jakari's last name is White, and that is his address, 515 Centennial Olympic Park.
Why is
Mrs. Rucker, is that where you live as well?
No.
Okay.
All right. I'm sounding for Mr. White. Okay, hearing none. Mr. Rogowski, is this your client?
Yes, it is, Your Honor.
All right, please proceed.
Yes, Your Honor. Come before you is Ms. Blanc. She's 30 years of age. She does have a good address at 555 McAfee Street, and that is apartment 302 in Atlanta, Georgia. Your Honor, she's been residing in the state of Georgia for the past 6 years, so she is most certainly not a flight risk. She is well established here. She also does have good employment. She had formerly been working with the Fulton County not with the Fulton County Public Defender's Office, Your Honor, but with Fulton County, was a former employee of Fulton County. And she does have a good degree in finance from Florida Memorial Institute in Miami. And she's currently studying for her CFA. So she does have a good amount of education, should be able to stay up on her feet, and should not be a flight risk. Your Honor, we would be asking in this case, given the fact that she has incredibly limited criminal history here. We do understand the facts as they've been relayed by the state, but at the moment, these are still allegations that Ms. Blanc plans on fighting. And with that being said, we would be asking in this case for a signature bond for Ms. Blanc, or in the alternative, if Your Honor is deeming a monetary bond, one not to exceed $3,000 in surety. Thank you.
All right. Defendant is going to receive a split bond. As to count one, the disorderly conduct, it'll be a $1,500 surety bond. As to false report of a crime, that'll be a $500 surety bond. And as to the criminal trespass, it's a $500 signature bond through the jail for a total of, what is that, $2,500 total, but she needs to make bond on $2,000. She's to stay away from that location, have no contact with either of the alleged victims in this case, have no alcohol, no drugs or weapons. And because of the $2,000 in surety, she's going to all purpose on the 6th, whereby aspects of the case can be revisited if necessary. Is there anything additional? All right, hearing none. Best of luck to you, Ms. Blanc. What do we have next?
Thank you, Judge.
Take care.
Position number 1.
All right. All right, please pronounce your last name.
Adepoju.
Mr. Adepoju, your case is 25 CR 00387Y. In this case, you are charged with battery. Do you understand your rights today?
Yes, ma'am.
All right, this is first arrest as well, so we'll go to Ms. Allen.
Thank you, Your Honor. This is an incident from yesterday, the 22nd
Why
of
does he
January at
have
about 9:30 in the
avatar?
morning. Police were called to 923.
Why do he have an
East Dunwoody
avatar,
Road.
cartoon avatar?
That's the address of the victim. His name is Kenny
Yeah, why does he have an avatar?
Igbola. I'm going to spell it for you. Bamigbola. He reports that he and the defendant share a family member who recently passed away. So the defendant lost a sister recently, and that sister had been married to the victim, Kenny. So police responded to that location when a call was made about an altercation and an injured person. On scene, they met with the victim. He reported that 2 weeks prior, his wife had passed away, that his family, who is associated with his wife, including her brother, had come to the location to talk to him. and make arrangements for her funeral. While there was an altercation, and the defendant in front of you picked up the vacuum cleaner and used a part of it to strike the victim in the head. He had an obvious laceration to his head. We have spoken to the victim today. He said that ever since his wife has passed, there have been some issues with the family, that the brother, the defendant, came along with the parents of his deceased wife unannounced, and refused to leave when he asked them to leave. He reported that they also broke some of his things, but at this point, all we have are warrants, Your Honor. He also reported that he has been treated for a concussion. So when we get medical documentation about that, there may be other charges. Mr. I'm going to try it again. Bambigbola, I believe, is on the Zoom. We spoke to him today. He's asking for a stay away and no contact. We'd ask for a $2,000 SOB through pretrial, no contact, and a stay away from that location. Again, that's 923 Peachtree Dunwoody Road. And if you'd sound for the victim.
Okay. Is Mr. Bamimbola, I'm sorry if I'm saying it incorrectly, present and wishes to make a brief statement? If so, please unmute, raise your right hand. Statements are not required, however.
Yes, Your Honor, I'm available.
All right, we need to turn your camera on, raise your right hand.
That's a cartoon. Take the cartoon off, fool.
Yes, my camera is on, please.
The camera is not on. Is this person's at Samsung driving? Remember, you cannot be driving while in court. You will be removed. Sir, so we still cannot see your video.
Oh my
Yes, I'm trying to do that. Can you hear me, Your Honor?
I can hear you. We have to be able to see you.
I have no idea why I'm unable to have the camera. It's unmuted, but I have no idea where I cannot select the camera.
You must have
You
it.
have to figure it out if you'd like to make a statement today,
Yes, I'd like to make a statement.
but you need to figure out the camera. Ms. McLeod, I see you online. Can you give the jail a call to speak to the young lady waiting to speak to you?
Good afternoon, Your Honor. I have already spoken with Ms. Evans.
Oh, okay. Thank you.
You're welcome.
Why is his phone doing that?
Okay, so you need to log off and then come back on with a different device. All
Yes,
right.
I'll do that, ma'am.
All right, Mr. Rogowski.
Yes, Your Honor. Come before you is Mr. Adepoju. He is 42 years of age. He does have a good address, and that's going to be at 2200 Duluth Highway, apartment 4112. Your Honor, he's been living here since 2011, so he has sufficient community ties in the Atlanta area here. His parents, his wife, his children all do live here as well. He has 2 kids, ages 7 and 8 years old. Additionally, he also has a third one on the way and is expected in 5 weeks. So he is about to become a father for the 3rd time here. He does have good employment. He's a principal trainer and analyst for ENR Systems, has been working with them for the past 11 years. And he does also travel. So we would ask for an allowance to travel out of state. That is a requirement of his employment. He does have multiple degrees. He has one in zoology, as well as a degree in computer science. Your Honor, he also is about to start for a master's program as well at Georgia State to do a master's with information systems. So, Your Honor, given that, we would ask, because he is not a flight risk, as well as his indigent status, we would be asking Mr. Adepoju receive a signature bond so he can continue on with his regular life here, taking care of his family. As you had already heard, he's experienced a number of great tragedies in his family recently. I know that this is most certainly not making anything easier for him, but what I will say is that he is most certainly deserving of a signature bond, and he has been a great candidate to return. So we would be requesting that at this time. Thank you.
Okay. Mr. Bamimbola, I can see you now. Please raise your right hand. Do you swear on the firm testimony gives the truth to the best of your knowledge?
Yes, I do, Your Honor.
All right. What I'm most concerned with are concerns for your safety and desire for contact. What would you like to tell me?
Yeah, I would like absolutely no contact. I'm actually in the process of getting a protection order against the gentleman and also his family. My wife's burial is in a week, and they have shown both himself, his brothers, and the family to be very violent and very disruptive. I would like to have absolutely no contact with them, and I'm in the process of getting the protection order against them as well.
All right. I appreciate you coming to court and making that statement.
I would also like to correct the address. The address is slightly wrong. It's apartment 923.
No, don't, if you can help, I'd like your address not to be on the record.
Yes,
Is there
ma'am.
an advocate on the line that he could chat the address to? So someone's gonna send you a
Yes,
message?
Your Honor.
Thank you. Just chat that address back, okay?
Yes, ma'am. Thanks, Your Honor.
All right, thank you. Okay, defendant is gonna receive a $3,000 signature bond at level 1 through pretrial services. He's gonna take the 1-day anger awareness course. He's to have no contact with the alleged victim and stay away from that location. Additionally, he's to have no drugs, no alcohol, no weapons, and he will be reset for the notice as he is receiving the signature bond through pretrial services. Is there anything additional?
What about his travel?
All right, best of luck to all parties concerned.
There you go.
Who do we have next?
We can go back to position number 8, Ms. Evans.
That attorney sucks.
Okay, I've heard the facts as alleged. Ms. McLeod has not though, so Ms. McCockey, if you give us a brief summation, it is, oh, and we do need the history again. Mr. Howard, can you give us Ms. Evans' history?
19 on probation out of Greene County, ag assault. 2024 battery arrest. 2023 and 2024 parole. 2023 false report of a crime conviction. 2014 ag assault conviction. 2015 criminal attempt to commit a felony. Possession of tools for the commission of a crime conviction.
Thank you. Ms. McCockey?
Yes, Your Honor. The victim in this case is Kenneth V. Austin. The parties had been dating for about a year and living together for about a month when this incident occurred. They were having a verbal dispute that turned physical when the defendant bit the victim's hand, leaving bite marks. The victim did tell officers that he was afraid for his life and fled the location after this. The state's recommendation is a $1,500 surety bond that is based on the defendant's history. No further contact with Kenneth V. Austin. Stay away from that incident location so long as Mr. Austin lives there. No drugs, weapons, or alcohol while out on bond, and that she undergo an anger awareness class.
All right, thank you. Ms. McLeod?
Yes, Your Honor. My client is 43 years old. She tells me that she and the alleged victim have been in a relationship for some time and that they live together. She tells me that both their names are on the lease at the residence where she lives. She has asked me to petition the court for signature bond for her. I understand that she has some history, but she says otherwise she will not be able to get out because she's not in a position to pay for a bond. She does tell me, Your Honor, that if the court says that she cannot have any further contact with the alleged victim, that she does have some place else where she can go. But she needs to get out of jail, she tells me, because otherwise she will lose everything if she stays in jail. She would also like to have a one-time police escort back to the location if the court says that she cannot reside there any longer. Nothing further, Your Honor.
All right. Defendant is going to receive a $1,000 surety bond. She's to have no contact with the alleged victim. Stay away from that location. She can return one time with a member of law enforcement, and she's to have no alcohol, drugs, weapons. She will be reset to all purpose on the 6th, whereby bond conditions can be revisited. Is there anything additional?
Nothing further, Your Honor.
All right, Ms. Evans, best of luck to you. Ms. McLeod, does that conclude your business today?
Yes, Your Honor.
Before we let Ms. McLeod go, is there anyone else who might need a conflict attorney that we are aware of, Mr. McLean? Or Mr. Rogowski?
No.
Okay.
At this time, Your Honor, I don't believe so.
All right, just wanted to make sure. Thank you, Ms. McLeod, for stepping in.
You're welcome.
Take care. Have a good afternoon.
You too,
All right.
Your Honor.
Who do we have next?
Number 4, Butler.
All right, good afternoon. Are you Jacobus Butler?
Yes, ma'am.
All right, your case is 25 CR 0000383Y. In this case, you're charged with simple battery, family violence, and reckless conduct. Do you understand your rights today? Is that a yes? You understand your rights?
Yes, ma'am.
All right, Mr. Howard.
15, open battery out of the cab. 2024 FTA, 2023 FTA, 2021 disorderly conduct conviction, 2021 arrest related to a CWAC charge, 2017 probation. I think the CWAC charge originated from 2012 in another state. That's it.
Okay. Ms. Allen?
Thank you, Your Honor. The defendant also has a NOLO for a NOLO conviction or plea for battery family violence out of this jurisdiction in a 21 CR case. This is an incident from the 15th of January. The location is 2210 Sullivan Road in College Park. It's actually at a bus stop out in public. The police responded to the location because the 911 caller was actually a witness, the driver of a bus. On scene, police spoke to that driver as well as another MARTA employee who reported seeing the defendant punching repeatedly and kicking the victim, Jocelyn Harris. On scene, they spoke, the police officers did, to Jocelyn Harris. She reported that during an argument with a defendant who she shares a child with, she wanted to catch the bus. 3 buses came. He prevented her from getting on those buses. He snatched the stroller from her with the baby that she had with her, initials EM, in that stroller. This was witnessed by the bus driver, and the stroller and the altercation actually took place in the street. The victim reported that the defendant grabbed her, punched her, obstructed her from getting on the bus, and snatched the stroller. The bus driver told police that she initially thought that this was some kind of a playful dispute, then realized it was much more serious. She saw the victim trying to get onto the bus. She opened the doors and then closed them quickly to protect the victim and create a barrier, preventing the defendant from getting in after her. The defendant was screaming at the victim, being very violent. She was trying to defend herself. There were no visible injuries seen on the victim at that time. While police spoke with her on the scene, she received a call from the defendant asking her, "Why are you talking to them folks?" Police then spoke to the defendant. He said that the victim had assaulted him and claimed that he'd only been pushing her to protect himself, despite the obvious statements from witnesses who are unrelated. This defendant you did hear has an open battery in DeKalb, has a battery family violence out of Fulton County, multiple failure to appears, and is a convicted felon out of the state of Mississippi. I believe his address is a Mississippi address. We tried to get in touch with the victim today, Mrs. Jocelyn Harris. We have not been successful, but we will continue those attempts. If you'd sound for her in case she got one of our messages, Your Honor. We're asking for a $5,000 surety. No contact with Mrs. Harris or her children. Stay away from wherever she may be. And no drugs, alcohol, or weapons. Thank you.
Is Jocelyn Harris on this Zoom call and wishes to make a statement? Okay, I don't see anyone with that name. Sounding again for Jocelyn Harris. All right, Mr. Rogowski.
Yes, Your Honor. Thank you. Come before you today is Mr. Butler. He is 36 years of age. He does have a good address at 978 Peoples Street, and that's Southwest Atlanta, Georgia, apartment A. He has been residing in Atlanta for the past 6 years or so. He does have family here. His brother stays out in Cobb. Your Honor, he also did just have a child. This child was literally brought home yesterday, was born premature, a baby girl named Chloe. So he is very much looking forward to, that is his first child, becoming a father here, and is very much looking forward to getting out from this so that way he can go and take care of that child. So we would most certainly ask that he is allowed to see that child if released on bond here. Your Honor, he does have a certification. He is certified in heavy equipment operation. So that should be very good towards proving Mr. Butler getting employment here, as well as his GED. So he does have some education as well. Your Honor, today we would be asking, given the circumstances here, we would be asking, because he cannot really afford much for a signature bond, or in the alternative, if Your Honor is not willing to grant that, a surety not to exceed 1,000. Thank you.
And the child he just had is with Ms. Harris?
I do believe so, Your Honor.
Oh, okay. All right. Defendant is going to receive a $4,000 surety bond. It's going to be $3,000 on the simple battery and $1,000 on the reckless conduct. He's to have no contact with the alleged victim. However, I will allow him to coordinate transfer of the child through a third party. He's to stay away from wherever she resides, have no alcohol, no drugs, no weapons as a condition, and he's being reset to all purpose on the 6th. Is there anything additional?
Your Honor, is the defendant and the victim, Mrs. Harris, are they married?
I'm not unaware. Do you know Mr. Rogalski?
I am unaware as well, Your Honor.
Okay. Does he have any other children with her, or is this the only child they share?
I do believe that this is the only child. I believe that this is his first child in total.
Okay. I'm going to let it stay as is. I understand your concerns, Ms. Allen. All right. Anything additional? Okay. Best of luck to Mr. Butler. Who do we have next?
Petition number 16, Mr. Watkins.
Mr. Watkins, your case is
Go ahead, I'm ready.
25
Oh, it's on
CR.
hold.
What's happening? Please mute whoever that is. 25 CR 0003272E. In this case, you're charged with giving false information and obstruction. You understand your rights?
Yes, ma'am.
Mr. McLean, have you had the opportunity to interview him?
I have.
All right. Mr. Howard, can I have the history, please?
11. On probation out of car, possession of marijuana. 2024 FTA. 2024 PR conviction. It was an FTA with that arrest as well. 2023 probation. 2022 battery DV conviction. 2017 possession of a firearm by convicted felon or felony first offender conviction. 2017 sale of marijuana obstruction conviction. And a 2016 sale of marijuana conviction. I stopped there.
Okay, thank you. Ms. Allen, please. Oh, is it, or is this Ms. McCarthy?
It's mine, Your Honor.
All right, please proceed.
This incident happened at 9995 Old Dogwood Road in Roswell. Officers observed the defendant walking his dog without a leash in the parking lot, which is a violation of the Roswell City Leash Ordinance. Officers asked for the defendant's identifying information in order to issue him a warning, and he gave them the fake name of Andrew Baxter and fake date of birth of May 16, 2004. As the officer was returning to his patrol car, the defendant fled on foot. The defendant currently has a $2,000 surety bond. We would just ask that the bond remain the same as it is. FTA and the fact that he ran from officers, there is a concern that he may be a flight risk and also that he may not show up to court. Given his history, there is also a concern that he will reoffend. No drugs, weapons, or alcohol while out on bond.
All right, Mr. McClain.
Your Honor, my client with high school education is 25 years old. He works landscaping at Cut Buddies. That's the name of his firm. He does live streaming and influencing. He has done paralegal work. Your Honor, this case, even with the arrest history, would of course call for a signature bond. Thank you.
All right, defendant's gonna receive $1,000 surety bond, 500 on each count. And he's had no drugs, alcohol, or weapons, and he's going to all purpose on the 6th. Is there anything additional? All right, best of luck to you, Mr. Watkins. Who do we have next?
Position number.
I'm sorry, I can't hear. Position.
Position number 5, Mr. Court.
Okay, thank you. All right, Mr. Quirk, your case is 25 CR 0038 I'm sorry, 0000381G. In this case, you're charged with possession and use of drug-related objects and criminal trespass. If you understand your rights, please give me a thumbs up. Do you understand your rights? All right, thank you. Mr. Howard?
4 total. Resident of Jackson, Mississippi. 2022 trespass, willful. 2015 escape, carjacking, kidnapping, destroying, or injuring licensed communication system, which is out of state. That's it.
Okay. Ms. Allen?
Thank you, Your Honor. We're asking for a $2,000 surety, no drugs, alcohol, or weapons, and to stay away from the location. We'd also request a social worker visit. On the 22nd of January, police were called to 535 Lee Street Southwest. That's the Texaco station. The defendant had been reported on the property standing in front of the location, and he would not leave after being asked to multiple times by the employees there. He was not a customer. He had not come in and bought anything. When police encountered the defendant and also asked him to leave, he declined that request. He then pulled his glass pipe out of his pocket with a lighter and proceeded to smoke it in front of officers. He was placed under arrest.
Okay. All right, Mr. Rogowski?
Yes, Your Honor, come before you is Mr. Cork. He is 24 years of age. The address that we have for him is in Jackson, Mississippi, and that's going to be 227 Delaware Avenue. Your Honor, he's only been in town for the past 2 or 3 weeks. We would state here that we would like to stress that these allegations are not violent in nature, which does cut in his favor towards being granted a bond. We do think that that makes him less of a risk to reoffend. We would also state that he does have good work experience. He is not currently working, but he's been working in waste management previous to this, as well as a number of different restaurants, so he can find work. Your Honor, he made it to the 8th grade in school. And again, with Mr. Cork here, these are nonviolent allegations. We would just stress that he doesn't really have anybody to pay his bond. He is indigent. And we would ask that he be allowed to return back to Jackson, Mississippi if left on release here. And we would be asking for a signature bond for that to occur. Thank you.
All right. Defendant's going to receive a $2,000 split bond. It's $1,000 SOB through the jail on the count 1, the possession, and $1,000 surety on the criminal trespass. He's to stay away from that location on Lee Street, have no alcohol, drugs, or weapons, and he is going to all purpose on the 6th. Is there anything additional? All right. Best of luck to you, Mr. Cork. What do we have next? Oh, if he's saying something, he's muted. I can't hear what he's saying.
Spanish interpreter, they waiting in courtroom 1 if you already.
Oh,
Yes.
I didn't know we had that.
Yes, Your Honor. Position number 2, Mr. Martin Barreto, does require a Spanish interpreter.
Okay, Ms. Chancey's on the line, so we can put her in the breakout.
Perfect.
Ms.
Thank you.
Chancey, please raise your right hand. Do you swear or affirm today that you'll make an accurate translation from English to Spanish, Spanish to English to the best of your skills, knowledge, and abilities?
Yes, Your Honor, I do.
All right, thank you, Ms. Chancey. If we could place Ms. Chancey in the breakout, please. And
Your Honor, if I also may join that breakout so I can.
Of course, yes, please. That was my intent. And can we take a case that belongs to Mr. McLean?
We could do number 10, Mr. Hardiman. Come on.
All right. All right, good afternoon, Mr. Hardiman. Please come forward. Your case is 25 CR 0000374 Y. In this case, you're charged with using a telephone or communication for harassing purposes and terroristic threats back in 2023. Do you understand your rights?
Yes, ma'am. Yes, ma'am.
All right, can I have the history, please?
14 on probation for harassing phone calls as of July. Appears to have open stalking case. 2021 terroristic threats that was dismissed. 2020 obstruction conviction. 2016 battery DV no load. A couple of battery DVs that were dismissed from 2014 and 15. Most of the history come out of Clayton County.
Okay. All right, Ms. Mokake?
Yes, Your Honor. The victim in this case is Ms. Tara Caldwell. The defendant is accused of threatening and harassing the victim through the phone and also through social media communications. He sent several threatening messages to her through text and social media, threatening to harm her. In one of the communications, he referenced her residence by asking if she lived there and then told her to come outside. He then sent her a picture after he sent that message, and the picture was of him pointing a pistol at the camera. The defendant was contacting the victim because he said that she had been arguing with his favorite cousin. The victim advised that she doesn't know the defendant and she also doesn't know his cousin. He currently has a $2,000 surety bond. We would just ask that that surety bond remain the same. And based on his history, it seems like he has a pattern of this type of behavior. So there is a concern for the public at large, as well as for the victim. No further contact with the victim, Ms. Tara Caldwell. Our office has reached out, but we have not been able to make contact with her. Stay away from the victim's residence, wherever that may be. No drugs, weapons, or alcohol while out on bond. And if he does have any firearms in his possession, as the warrant indicates, he should turn those in immediately.
All right, is
And I
Ms.
would just
Caldwell present and wishes to make a statement? Okay, I don't see anyone with that name. It's sounding again for Ms. Caldwell. Okay, Mr. McLean?
Your Honor, Mr. Hardiman is 30 years old, graduate of McNair High School. He has those prior arrests. The date of this allegation precedes some remedial efforts by the society, so I would think it would be logical to ask for a signature bond. He is a manager and he's been a manager in business for 5 years. Has stable address, emergency numbers, phone numbers, should not be a problem for any further activity. And he'll make court. Thank you.
All right, defendant's gonna receive a $1,500 surety bond, $500 on count 1, $1,000 on count 2. He's to have no contact with Ms. Caldwell, stay away from wherever she resides, have no alcohol, drugs, or weapons, and he is being reset to state all purpose on the 6th of February. Is there anything additional?
Nothing.
No, Your Honor.
All right, best of luck to you, Mr. Hardiman. That concludes your case. Who do we have next?
Judge Williams, can you repeat the bond amount, please?
1,500 surety.
Okay, thank you. We're gonna do position number 11, Hernandez.
All right, good afternoon. Your case, please come forward. Yes, your case is 25 CR 0000373J. In this case, you're charged with public drunkenness, obstruction, and disorderly conduct. You understand your rights?
Yes, sir.
All right, Mr. Howard.
8, resident of Houston, Texas. 2024 collision involving damage to vehicle. 2022 driving while intoxicated. That one was dismissed. You had a 2012 that was a conviction, and a 2019 vandalized property. That's it.
All right, thank you, Ms. Mokake.
Yes, Your Honor. This incident location is 2301 Sullivan Road in College Park, which is the Hilton Hotel. The defendant is accused of being drunk and disorderly at the incident location. He touched an unknown female's breast, touched an engineer, and then touched himself inappropriately, and then proceeded to spit. He then told the female front desk employee something sexually inappropriate. Officers were advised that the defendant had consumed several shots and also a lot of wine. Officers arrived at his room and they did attempt to detain him. He refused their verbal commands and also refused to put his hands behind his back. And he also refused to walk. He had to be dragged out of his room. The state's recommendation is a $2,500 surety bond, that he stay away from the incident location, no drugs, weapons, or alcohol while out on bond, and also no contact with any employees of that Hilton Hotel.
All right, Mr. McLean.
Your Honor, Mr. Hernandez is 35 years old. He has an associate's degree in biology. He works in clinical research for a pharma company. Given the nature of this being a situation where he is claimed to have done several things while completely drunk, I would think now while sober, he's not going to have any problems. He's got stable address, phone numbers, He's not going to miss court, and we would ask for a signature bond, Your Honor, given the charges.
All right. Defendant's gonna receive a $1,500 surety bond. That's $500 on each count. He is to stay away from that location on Sullivan Road, have no alcohol, no drugs, no weapons, and he is going to the all-purpose calendar on the 6th. Is there anything additional?
Nothing.
All right, best of luck to you, Mr. Hernandez. Who do we have next? The interpretation case is back. Are we ready to go forward, Mr. Rogowski?
We are, Your Honor.
All right. Give me one moment. We're gonna take a 2-minute break for 1 second. I need to reset something. Yeah. All right, my apologies. What position was this? Position 3?
Your Honor, it's position number 2.
2. I'm having some technical issues with my laptop, so I hope you all do not lose me abruptly. If you do, I will be back on my phone. All right, Mr. Barreto, good afternoon. I'm Judge Melanie Williams, and your case is 25 CR 0000386J.
Buenas tardes, señor Barreto. Yo soy la jueza Melanie Williams y su número de caso es 25 CR 000-386J.
In this case, you are charged with obstruction, public drunkenness, and loitering and prowling with the offense date of January the 22nd of this year.
En este caso, usted está acusado por obstrucción a la autoridad, por ebriedad en público y por vagabundear y haraganear. Eso con el día del incidente siendo el 22 de junio de este año.
You have an absolute right to remain silent. Anything you say can and will be used against you.
Usted tiene el absoluto derecho a guardar silencio. Todo lo que diga puede y será utilizado en su contra.
You have a right to an attorney today, and Mr. Rogowski is here to represent you.
Usted tiene el derecho a tener un abogado. Hoy el señor Rogowski está aquí representándolo.
As you can see, I'm conducting this hearing by video. It's also being recorded. That means any member of the public can log on and watch this.
Como usted puede ver, estoy conduciendo esta audiencia con video y también está siendo grabada, lo que quiere decir que cualquier miembro en el público puede entrar a la plataforma y observar esto.
Do you understand your rights and how I'm conducting this hearing today?
¿Entiende sus derechos y cómo estoy conduciendo esta audiencia hoy?
Sí.
Yes.
All right. Can I have the history, Mr. Howard?
Los antecedentes, señor Howard.
2024, driving without a valid license.
Manejar sin licencia en el 2024.
2023, alien inadmissibility. That's all.
Y por inmigrante indocumentado en el 2023. Eso es todo.
All right, thank you. Ms. Allen, please proceed.
Thank you, Your Honor. 911 call reporting a suspicious person looking into the windows of the apartments at 100 Preakness Drive was received on the 22nd of January.
El 22 de enero se recibió una llamada del 911 denunciando una persona sospechosa mirando a través de las ventanas de los departamentos en el 100 de Preakness Drive.
On scene, police made contact with the defendant who matched the description provided by the caller.
Y en el lugar del incidente, la policía contactó al acusado que combinaba con la descripción provista por el individuo que hizo la llamada.
Although the defendant had slurred speech and smelled strongly of alcohol, He was able to provide his Venezuelan passport to the police, and he claimed that he lived at the location.
Aunque el acusado balbuceaba y olía fuertemente a alcohol, él pudo proveer su pasaporte venezolano al oficial y declaró que él vivía en este lugar.
He's reported as appearing confused and maybe even lost, and he was shoeless.
Él fue denunciado como verse confundido, quizás perdido, y no calzaba zapatos.
When police ran his information in the system, his address came back to an apartment complex, not the location, Your Honor.
Cuando la policía buscó la información en el sistema, su dirección regresó con la de un departamento en un complejo que no era el lugar en donde estaba su señoría.
He was also seen to have a failure to appear warrant for that driving without a license arrest you heard about.
También se ve que tuvo una falta de comparecencia que emitió una orden de arresto debido a el ser arrestado por falta de licencia.
Police went to detain the defendant and he obstructed in multiple ways.
La policía fue a detenerlo y el acusado los obstaculizó en múltiples maneras.
He pulled his arms away, refused to put his hands behind his back, became loud and boisterous and unruly.
Él sacaba sus brazos, él no rechazó poner sus manos detrás de su espalda y hablaba en voz alta y empezó a actuar de manera desordenada.
Once he was put into the police vehicle and transported, he removed his arms from his handcuffs and urinated on himself.
Una vez que se lo puso en el patrullero y fue transportado, él se sacó las esposas de sus manos y orinó y se orinó.
The state's asking for a $3,000 surety, no drugs, alcohol, or weapons, to stay away from that location, and we'd ask for a social worker visit, Your Honor.
La fiscalía está pidiendo por una fianza de $3,000 bajo garantía, que se prohíbe el uso de drogas, alcohol y armas, que se mantenga distanciado del lugar del incidente y pedimos que una trabajadora o trabajador social lo visite, su señoría.
All right, thank you. Mr. Rogowski?
Yes, Your Honor. Come before you is Mr. Barreto. He is 23 years of age.
Estoy aquí con el señor Barreto, que tiene 23 años de edad.
Does have an address at 1712 Saratoga Drive in Alpharetta, Georgia.
Él tiene una dirección en el 1712 Saratoga Drive en Alpharetta, Georgia.
He has been living for the past few months in the Atlanta area.
Él ha vivido por los últimos pocos meses en el área de Atlanta.
And he has been working cleaning houses with stable income doing that job.
Y él ha estado limpiando casas con un ingreso estable haciendo ese trabajo.
He is also a high school graduate.
También se graduó de la escuela secundaria.
At this time, given Mr. Barreto's limited criminal history,
Dado al tener pocos antecedentes penales el señor Barreto,
we would be requesting a signature bond.
Solicitamos una fianza bajo firma,
as his indigent status would make him unable to pay any monetary.
debido a que su estado indigente financiero lo haría incapaz de pagar una cantidad de dinero.
Thank you.
Gracias.
All Okay, defendant is gonna receive a $75 cash bond, $25 on each count. He's to stay away from that location, have no alcohol, no drugs, no weapons. Because it's a cash bond, he's going to all purpose.
Muy bien, el acusado va a recibir una fianza en efectivo de $75. Eso sería $25 por cada cargo. Él debe mantenerse distanciado del lugar del incidente. Se prohíbe el uso de alcohol o drogas y armas debido a que es una fianza en efectivo. Él va a cumplir este propósito.
Is there anything additional?
¿Hay algo más?
All right, hearing none, best of luck to you, sir. That concludes your case.
Muy bien. Al no escuchar nada, mucha suerte, señor. Esto concluye por hoy su caso.
All right, Ms. Chancey, will you sound to see if anyone else needs your assistance before you go?
Yes, Your Honor. ¿Hay alguien que necesite un intérprete en español para hablar con la señora jueza? Por favor, prenda su cámara y micrófono y avísenos.
Hearing none, thank you, Ms. Chancey. Take care. Have a good
You're
afternoon.
welcome, Your Honor. Have a good day.
Bye-bye.
Bye-bye.
All right, who do we have next?
Number 6.
Okay, Mr. Coyle, your case is 25 CR 0003788H. In this case, you're charged with simple battery, hindering someone who's trying to make an emergency call, and criminal trespass. Do you understand your rights?
Yes.
All right, Mr. Howard.
Second, 03 robbery conviction.
Okay, thank you, Ms. Allen.
Thank you, Your Honor. This is an incident from yesterday, the 22nd of January. Police were called to the location. One second. Let me pull that up. So the backstory here, Your Honor, is that police had been to the location multiple times on the same day. This last time was about 2:30 in the afternoon. The police documents note that they'd been there at 6 a.m. and at 8 a.m. The defendant had been told to leave and not to return. This is a South Fulton case, Your Honor. So on scene the third time, police met with the victim, who is the wife, separated, estranged wife of the defendant. Her name is Kiara Coyle, Kiara. She reported that the defendant was trying to take her phone away from her to prevent her from calling 911. He was grabbing at her, and then he grabbed her physically and pushed her head into the wall multiple times, causing her to strike her head. She reported that he then took the phone of one of her children because she asked that child to call 911. The child's initials are AC. She reports that they've got 4 children together, actually. The defendant took the child's phone, and the mom, the victim, reports that she ran to the defendant's car to try to use his phone to call for help, at which point he then got into his vehicle and threatened her, saying that he was going to drive off and drag her behind him. All children were present, Your Honor. There were no obvious visible injuries to the victim at this time. We spoke to the victim, Mrs. Coyle, and I think she's joined us on the Zoom. She reports that they are estranged in the process of getting a divorce and that her boyfriend was present. The defendant showed up unannounced, and she reports that he actually punched her in the face. She did report that there'd been multiple times the police had been to the location in the same day. Ultimately, the defendant had been told to leave and not return. He had taken some of his belongings and in the process damaged some of hers. when he did return to the residence, this is when he assaulted her. He grabbed her by the neck as well, she reports. We'd asked for a $3,000 SOB through pretrial, Your Honor. He does have that conviction, but it is from 2003. No contact and to stay away from the location. And let me make sure I pull that up correctly. And if you would sound for the victim, we'd ask for no contact until there's an order of the Superior Court, Your Honor.
All right, Ms. Quill, I see you online. If you wish to make a statement, please come on your camera, raise your right hand. You're not required to do so. But if you wish to make a statement, this is your opportunity.
It's 2560 Fox Layer, Foxlair Trail. And that's College Park.
Okay.
Unfortunately, it's also South Fulton.
Okay. All right, I have sounded for Ms. Coyle. Mr. Rogowski.
Yes, Your Honor. Come before you is Mr. Coyle. He is 38 years of age. His address was that 2560 Foxlair Trail address in College Park. He also does have an alternative address, however, if Your Honor is inclined for release here. He does have an address at 164 Darby Runs Court, and that's in Huron, Georgia, where he would be residing with his uncle. Your Honor, he's been residing in the state of Georgia for the past 5 years. He is most certainly not a flight risk. He is well established here. He has been working as a contractor as well for the past 6 years. He does have a good amount of family here, as you had heard. I mean, his uncle lives nearby. He does also have 4 children, ages 4, 5, 7, and 8, so all pretty young. He did complete some college. He also did go to technical school and received his CDL, so he does have some certification for good employment past that contractor work, and he is also only 6 months away until he does own the truck that he is going to be continuing doing this contractor work with. So he is most certainly not going anywhere. He's very close. He's been working towards paying off this truck to expand his business for some time now. Your Honor, these at the moment are allegations that Mr. Coyle does plan on fighting. And so we would just ask that they are treated as allegations at the moment, and he does receive a signature bond so he can go out of here, continue being a productive member of society and working, as well as supporting those kids. So thank you, Your Honor.
All right, defendant is going to receive a $3,000 signature bond through pretrial services at level 2. That's $1,000 on each count. He's to have no contact with the alleged victim in this case. Stay away from that incident location. He's to have no alcohol, drugs, or weapons, and he's also going to take the 1-day anger awareness course. Is there anything additional? All right. Best of luck to you, sir. That concludes your case.
Okay, y'all, we're going to the parole in Utah.
I'd like to quickly talk about, you have 2 new disciplinaries. The first was October 3rd, 2024. I think it said there was unauthorized use of phones. What happened during this incident?
My dad's currently on his deathbed. And I didn't have money on my account to make a phone call, so I used someone else's account with their permission, and that's not allowed here in this jail. He was in,
I'm aware of that.
Yeah, he was in the Ogden Regional Hospital or the Huntsman Cancer Institute.
Yeah, I reviewed the written submissions that you submitted prior to the most recent hearing, discussing your father's health concerns, etc. Just so you know, I'm aware of that and don't want to cut you off, but do want to talk about the issues that led to this current hearing. So if I'm understanding correctly, did not have money on your books. You wanted to speak with your father. Therefore, you used another inmate's account to make that phone call, correct?
Yes.
Okay, the next write-up, November 2nd, 2024. This was the write-up that led to today's hearing. Looks like you had homemade alcohol in a protein container was found while you were being rolled up or moved. Your property was moving to a different housing section. Were you drinking alcohol at the time?
No.
Why did you have the alcohol on your property?
It wasn't even alcohol at the point, but the officer that found it said that its consistency was for making alcohol because there was bread or cornmeal next to the protein container. And
you deny that you were making homemade alcohol, brew, hooch, whatever it was called in the report. You deny that you were making that?
Yeah, and they still found me guilty of it. So
Yeah, certainly that's why we're here. You were found guilty of a disciplinary violation for having in your possession homemade alcohol in your property. So, but your statement is that you were not using alcohol, and you did not. This was not intended to be made into alcohol. Okay, but you had extra fruit in your property with bread. Is that what you were saying, or what was
fruit in a jar, and then there was cornmeal next to it in a bag that we were going to use to make tamales with, because it's like the most common thing that you can use to make tamales here in this jail.
Okay.
So
well, thank you for making your statement on that. That incident is the reason today's hearing was scheduled. So I think it's important that the board have a statement from you about what happened. Obviously, they'll have the official report for that disciplinary conviction as they're making a decision. I did want to check in. You've had multiple hearings. I conducted one of them. There's been multiple other hearings. After each of those hearings, the board has said it expects you to complete the sex offender treatment program. It's made paroles contingent on completing that. At this point, are you willing to do the program?
I literally will not be able to get back into the program due to that A13 write-up till, well, I can't reapply till February, which that is when the next group starts. So that's
Okay.
when I can reapply.
And is it still your understanding that it would take 9 months to complete the program?
10 months.
10 months?
Yeah.
Okay. And so back to the initial question, are you willing to do that? Just because at every other of the hearings, you said you're willing to do the program, the board has granted a parole contingent on it, and then you haven't gotten into the program. So do you have any, are you willing to do that? Do you have plans to do that? What's happening with that?
I'm at 16 months and some odd weeks till I expirate.
Correct.
By the time I can get into the program, it will be in June.
I said February, or you can apply in February, you get in June.
That's the next group is in February, so I can't necessarily get in the February group.
Okay.
So that puts me into the June group, which that's literally a year away from my expiration. And it takes me 10 months to complete the program, and it's 2 months from my expiration. So I'm like, there's not really a purpose in doing the program when I'm clear up to my expiration.
Okay. So the only reason you would do the program is to get a benefit of early release. You don't feel like you could benefit at all from the program?
Not really. I did the BRT in Beaver County Jail before I came to this jail. And it's literally the same program. As I could benefit from the Beaver County Jail BRT to here is literally the same programs, other than this is sexual based and the BRT is just cognitive behavioral.
Okay. And I'm just speaking here. I want to make sure the board has clear information as they're making a decision, because confusion and non-clear answers have led to confusion in past hearings. So you would not be willing to do the treatment program while incarcerated. If the board were inclined to grant a parole and allow you to do it at a halfway house, would you be willing to do that?
No, I will not.
Okay. Okay. Well, I think I have the information that I needed from you. Thank you for being patient so that I can provide the board with accurate information. I do want you to know I've read and reviewed all the statements you made at your past hearings. I've reviewed the written submissions, including the details regarding your family's medical situation, etc. But at this point in time, are there any other comments, questions, concerns that you'd like to bring up with me during the hearing, or anything else you'd like the board to know?
The only reason why I choose not to, like, if they gave me a chance to go out and do it in the halfway house, is because I literally was in the program doing everything I needed to be done to do, and the board still pulled my date, even though
Yeah, you self-removed. You didn't have enough time to do that. I'm familiar with that. Unfortunately, you self-removed, which prevented you from the board adjusting that to give you enough time to do that. But certainly, there's been some communication issues that weren't allowed to give you the time to do that. Sorry to cut you off, but certainly there was that aspect of you self-removed. You took yourself out of the program out of frustration, which is also an aspect in that. But please continue if I'm sorry to cut you off.
So that was around the same time that I found out about my dad's health issues. with me going to a halfway house and doing a program in the halfway house, if he does go, they're not going to allow me to go and do the meetings with him or do not the meetings, but his celebration of life or funeral or anything like that. So that is why I refuse to do it in the halfway house.
Well, certainly that wouldn't be allowed if you don't communicate. Certainly with programming, getting expectations met. If you're great, on supervision, you have to communicate with people to get things approved. So if that communication was not there, that obviously could not be approved. But I'll note your comments for the board. We have about a minute left in our scheduled hearing. Is there anything else you'd like the board to know?
No.
Okay.
Just the only reason why I won't do it at the halfway house is I won't be able to go out of state to do the celebration of life for my father. So I'm just kind of like, let it take its toll. Whatever happens, happens. I have 16 months to expirate, I just.
Okay.
Just want to get this behind me and move on, I have criminal charges in Evanston, Wyoming that I still have to take care of in order to even go up there. If I do get caught up in the state, I'm getting arrested anyway. So.
Well, at this point, we are out of time. What I'll do from here, thank you for your comments. I will include those. I've put together a report of what I reviewed before today's hearing. I'll include what you and I talked about at today's hearing in that report. I'll submit it to the members of the board. They'll consider your case as a whole, where we stand 16 months out from expiration, as you said, and they'll make a decision on what's appropriate from there. It usually takes between 2 to 4 weeks for a decision to be made. It will be sent to you in writing through the mail, and it will also be posted to the board's website if there's anyone in the community that would like to access it there. So with that, Mr. Rowley, thank you for being here and discussing these things with me. I do wish you the best of luck moving forward, and we'll go ahead and conclude.
Okay, thank you.
All right, y'all. Well, I don't know why it's muted, y'all. Let's see why it's muted. I don't know why it's muted. They got it muted. He must be on the phone. He got it muted. Probably waiting for the next person. He's still stuck in there. Look how clean that jail is, that prison. You like cursing in here, don't you, Rachel? It's the same thing. You're still cussing. Okay, why we don't hear him? They're raising their hand saying they don't hear him. They're raising their hand that we don't hear y'all.
On record.
Now
this is an original hearing for Stephen Wold, number 228366. Is that you, sir?
Yes, sir.
My name's Scott Manning. I'm a hearing officer with the Utah Board of Pardons and Parole, and I'll be conducting today's hearing. I am going to be taking testimony from you. Mr. Wold, if you'd raise your right hand, I'll swear you in. Do you swear that the testimony you provide today will be truthful and accurate?
Yes, I do.
Thank you. I do want to recognize victim of record, Brooke Taggart, who we have here with us today. Thank you for being here, Brooke. I'll be receiving testimony from Brooke here in just a few minutes, and I'll let you know when we are ready for that. Mr. Wold, did you receive at least 7 days written notice of today's hearing along with your blue disclosure packet?
Yes, I did.
So that disclosure packet contains the information that the board will be considering as they make a decision in your case. Part of the purpose of today's hearing is to allow you to point out any errors or inaccuracies with that information. I'm going to be going over quite a bit of that with you today. I have some questions about various things, but at this point in time, are there any errors or inaccuracies that you'd like to discuss with me?
I don't believe so.
Okay. So how I'd like to proceed, first, I'm going to give a brief overview of your case, conviction, sentence, your parole guideline date, a little bit about how today's hearing works. Second, we'll review the case in which you were committed to prison, the facts of what happened in that case. Third, we will have the victim impact statement. You will be able to respond to that statement if you'd like to after it's made. From there, I have some questions that I've prepared for you about what you've been doing since you arrived at the facility, your plans looking forward, etc. And then at the end of the hearing, I will give you, Mr. Wold, the final word, and you can state anything else you'd like to on the record. Does that sound okay to you?
Yes, sir.
Your commitment offense is aggravated sexual abuse of a child.
Woo!
First-degree felony.
Woo!
You're serving a sentence of between 15 years and up to life in prison. Based on my calculations, the minimum 15-year sentence will pass on November 27th of 2032. Your parole guideline, as established by the Utah Sentencing Commission based on this conviction, calls for 192 months incarceration. That guideline or recommended release date would lead to you being released on November 27th of 2033. The board is not bound by the guidelines in these cases. They act as a guideline or a starting point in the analysis. After today's hearing, the board will consider all relevant factors in this case to determine the appropriateness of a release, and if so, the timing, conditions, and contingencies of any such release. The factors that they will consider include the nature of your offenses, your criminal history, victim input and impact, your rehabilitative progress, etc. The case in which you're committed to prison is case 151402839. Originally, charges were filed in this case related to two separate victims. I believe a jury found you guilty of the charge related to one of those victims, but not guilty related to the charges involving a second victim. I note this, that there was a pre-sentence report that we received. The official summary in that pre-sentence report included behavior regarding both of these individuals. I believe at the objection of defense, an amended pre-sentence report was submitted, which includes only the behavior involving the victim of record in that conviction. I just note that we have both in our file and that the board has access to. As to the conviction, the abuse was reported in August of 2015. At that time, the victim was 15 years old and you were 26. The abuse in this case occurred in 2010 when the victim was 10 years old and you were 21 years old.
Wow.
You were the victim's uncle. The victim and her younger brother were dropped off to be watched by you at your residence. While sitting on the couch watching TV, you sat the victim on your lap and covered you and the victim with a blanket. You then put your hands into the victim's pants and underwear, making skin-to-skin contact. The report says you, quote, felt and pet the victim's vagina during this incident.
Yeah, this is
Looks like at the time of the pre-sentence report, you did not admit guilt. You said you were planning to appeal. In the board packet that you submitted to us, I've reviewed your written submission in the fall of 2010. I was babysitting my niece and nephew. I put a blanket over my niece while she was sitting on my lap. I reached my hand inside of her underwear and rubbed her vagina with my fingers. Is that summary accurate as to what happened in the case?
Yes, sir.
Would you like to make any further comments about the events or the abuse that occurred in this case?
No, sir.
And what led to you engaging in this behavior?
I made stupid choices. I had an addiction to pornography and I didn't seek help. I let my addictions grow, and it led me to act out sexually in a manner I'm ashamed of.
Wow, y'all. This is crazy. This is crazy.
Based on my review of the file, no restitution was requested or ordered. Based on your date of sentencing, the Board of Pardons does retain jurisdiction, I believe, to make restitution orders upon a request that's made and the proof the process is followed. Would you be willing to pay any restitution that is ordered in this case?
Yes, sir.
Okay. This time we'll move forward with the victim impact statement. Brooke, are you ready at this time to provide your statement?
Yes.
So you don't need to turn on your camera, but if you'd raise your right hand and just let me know when it's raised, I'll swear you in.
Yeah, don't put her face on.
It is raised.
Do you swear that the testimony you provide today will be truthful and accurate?
Oh, y'all.
Yes.
Thank you. Just so you know, thank you for attending today's hearing. The docket in the case noted that various statements were made at sentencing, but we've not been provided with that information. So thank you for being here and providing a statement. I'll take notes of what you say today. I may listen to today's hearing tomorrow to make sure the board members have a summary of that. But Brooke, you may proceed when you're ready.
Thank you. I am speaking to you today as the victim of child sex abuse, the crime which was perpetrated by my uncle, Stephen Wolf. This is incredibly difficult for me to put into words and speak about these terrible events that I've had to endure because of Stephen. While this may be difficult to discuss and relive, it is even more important that Stephen does not receive parole and instead carries out his sentence in custody. I'm not saying this out of hatred or revenge. My only hope is that justice continues to be served and Stephen's actions are met with the gravity that they deserve. I'm deeply concerned about Stephen being released at this time due to his risk to the community. I know that there are more victims of Stephen out there besides my sister and myself. There will be more victims if he is released.
Oh, it's two of them.
Stephen will go back to his wife, who is an elementary school teacher, and will go back to his favorite hangout spots, which include children's arcades.
Wow.
Well, Stephen may seem like a model prisoner on paper, and he may only be in custody on his first offense. Don't let the actions of a convicted felon sway your judgment as to who he really is. A pedophile who will reoffend if given the opportunity.
Wow.
There is a reason Stephen agreed to serve the maximum 15-year sentence of his actions, because he would rather hide behind the whole truth, a truth that he has yet to confess to. Stephen may tell you that he is a changed man, that he has found Jesus, and he claims to have repented for his actions. He can pray all day, but you can't pray pedophilia away.
Wow.
I trust that the parole board will take my words into consideration along with all other evidence as you make this critical decision. My greatest hope is to believe in the justice system is working to protect victims like me. The last thing I would want to happen is for him to reoffend and for another person to be in the same seat that I am in right now. And you, as the parole board, hold that power. Please prevent future child abuse from happening.
Thank you, Brooke, for being here and providing your statement. I've taken some notes. I'll listen to your statement tomorrow, and the board will have access to that recording as well, the 5 board members, as they're making a decision in this case. Mr. Wold, would you like to provide a brief response?
Yes, I would. I know I'm not supposed to address her, so I just say I hope that she can have the healing that she needs. I am remorseful for the actions that I did. I was living in a life of secrecy, of hypocrisy, and I can only imagine the pain that I put her through hearing that response that she said. And I am sorry for the pain I've caused to her and her family, to my family. I have no desire to reoffend, but I understand that I had hurt her, and I understand that she wants for justice to be done. And I do pray for her. I pray for her sister. I pray for her family and my family as well.
Well, I will note your comments as well in my report for the board. I note, as far as your history, you have no past criminal convictions outside of this case. Is that correct?
There was one class C misdemeanor from the BYU Police Department.
That was dismissed. Is that correct?
That's correct, sir. But that's all.
And you've never been supervised in the community. Is that correct?
That's correct.
And you've reported you've never used abused drugs or alcohol in your past. Is that accurate?
That's accurate.
Note, since arriving at the prison in December of 2017, you've successfully completed many life skills classes, MRT, victim impact. I think you're in currently the Kane County Substance Use Treatment Program. Based on your written submissions, I think you've discussed this as focusing on addiction to pornography, also hoping to develop coping strategies regarding depression, anxiety, stress. The reports from the prison, the Utah Department of Corrections say you're progressing in that program, but what have you learned in the classes or programs that you've taken?
So I guess the biggest thing that I've learned is that addiction thrives in secrecy. That was one of the biggest things that I've learned to me, and that I need to be able to recognize my warning signs and my triggers. I need to have a good support group and to lean on them, to ask for help, and to share when I'm struggling, to share when I'm having successes, just open communication with my loved ones. And I'm blessed with a good support group. And so what I've learned is I do have addictions. I do need to work on them and be aware of them. And I need to be honest with my parole officer, with my wife, with my parents, of things when they are going wrong that I need help. And I've learned some coping strategies for when I get anxious, for when I get depressed, for when I'm lonely or feel just feeling down. And I've learned that the higher power, which for me is God, is essential in my growth and in my spiritual well-being.
I wonder why
I do note you've not taken any sex offense treatment specifically at this time. Documents in the file discuss you reaching out to that program, attempting to get into the program. The documents state, I think you were placed on the tracking list. It was explained generally this original hearing is to have an initial appearance on the case. After the hearing, generally the board will set expectations for treatment moving forward. Right, they'll make considerations as far as timing regarding the legal minimum sentence, the maximum sentence, the guidelines will be used in the timing of that. After today's hearing, I think there will be some direction on that at the board. The Department of Corrections has internal risk assessments that result in certain programs. So it could be possible the board sets an expectation that you complete all that is recommended. There's various things they could do, but it sounds like you're willing to complete any sex offense treatment that is ordered. Is that accurate?
Taking none notice.
Absolutely.
Okay. And like I said, we have not received a thorough, full sex offense risk assessment at this time. I believe really the minimum sentence that you're serving, the timing of things is probably the reason for that. We did receive a pre-original hearing risk assessment that's based on demographic factors of your age, history, offense type. There's various non-changing factors that result in risk assessments. We have that. But generally, there's more thorough, detailed assessments involving specific evaluators, discussing things personally with you, etc. It's possible that the board would order at a future time a sex offense assessment to get further input about treatment and what's appropriate in your case. It's also, like I said, I think it's possible the board could just make a decision on those things with what we have. But just wanted that information out there. And it sounds like you'd be willing to comply and participate in such an assessment. Is that accurate?
Yes, sir.
Okay. I note you do not have any disciplinary violations. The institutional progress report lists 12 positive C notes, 1 negative. It reports housing staff having no issues or problems with your behavior and attitude. It lists many jobs that you've had since you arrived at the facility. I believe in all of those jobs, you've received good or excellent ratings. So I'll include that information in my report to the board. If in the future, if at some point, if and when you are granted parole, I have your written submissions about release plans, what that would look like as far as where you plan to live, work, treatment. But if you are granted parole, what would that look like in your mind?
It'd be a blessing, number one. In my mind, it would be, I go live with my wife. We have a home in Orem, Utah. I'd go live with her. I would try to get work back at Thrive Nursery, which is where I worked for the 2 previous years up until my incarceration as a CDL driver. And my boss has already told me he'd accept me back, Ryan McCann. And so I would like to work there. I also worked at Burton Lumber because that's about a 9-month-a-year job with them, the snow winter time being off because it's a landscape business. I would work for Burton Lumber in Linden, that's right next to my home. And I left them in good standing there. They were good to me. I was good to them as an employee. So I'd be working as a CDL driver again. And I would stay local in Utah. I'd want to be home each night with my wife. I'd be back involved with the Church of Jesus Christ of Latter-day Saints. I would be attending any counseling. I've been attending the 12-step program since I came into incarceration. And attending the Alcoholics Anonymous here as well, because it gives me a chance to work on my addiction, and they've been welcoming to that. So I'd be going through therapy. I'd be going to the 12-step. I'd be working. I'd be with my wife. I'd try to have a family with her. And I would
Wait a minute, try to have a family with her. Hold up.
Anything that the board asked that my parole officer would ask, I'd go by those agreements because I want to get a second chance and to show that I am not the man who committed that offense, that I am not the same man, excuse me, who committed that offense.
I do note I reviewed various letters of support from family members, your parents, wife, aunts, friends. I've put together a summary of those things, and the board will consider those as they're making a decision. I do note if and when you are granted parole, it will likely include, almost certainly, it will include Group A sex offender conditions. That includes, but is not limited to, completing all recommended sex offense treatment, abiding by a curfew as ordered, having no victim contact without prior approval from adult probation and parole, having no contact or association with children under the age of 18 without proper approvals from supervisors and therapists, not enter places where children congregate or are reasonably expected to be, not possess sexual stimulus material, submit to random polygraphs, have employment and residences approved, etc. There's more, but those are some of the core concepts of those conditions. Is that something you'd be willing to abide by?
100%.
He was 21.
And how's your mental health currently?
It's good. It's difficult being down in a county jail to not have my visits, my in-person visits with my wife, my parents, and other loved ones. That part's difficult, but we have a good ward. The program's a good thing here, and my mental health is doing well.
Okay. Well, those are the questions that I have for you. What else would you like the Board of Pardons to know?
I'd just like them to know that my addiction thrived because of the secrecy. That's where my addiction led to pornography and then led to me acting out sexually to harm my niece. And what I'd like the Board of Pardons to know is that I'm committed to living a life that is going to be loving, that is going to be kind, that's going to be a good community member, that I want to be supportive, and I will follow whatever conditions they ask of me, because I want to prove to them and my loved ones that I'm safe to be around
kids.
And that I do believe in the atonement of Jesus Christ and the ability to be forgiven of my sins. That's what I want them to know.
What I'll do from here is take your case under advisement. I've put together a report of what I reviewed before today's hearing. I'll include what's been discussed at today's hearing into that report, and then I'll submit that to the members of the board. There's 5 members of the board. They ultimately will make the decision by a majority vote. That usually takes, we say, up to 2 to 4 weeks. Sometimes it's a few days. Sometimes it's quicker than other times. It can take up to a few weeks. When the decision is made, we will send that decision in writing to you, Mr. Wold, through the mail. And for anyone in the community that would like access to that decision, it will be posted to the Board of Pardons website. And certainly anyone can call our offices to, we can walk through what the decision means or what is included in that decision.
Eye on that one.
That's how we will proceed. With that, thank you to everyone who's participated in today's hearing. I wish you the best of luck moving forward, and we'll go ahead and conclude.
It's the end, y'all.
Thank you.
That's the end of the meetings. What's his name? What was the guy name? I gotta go back and look at it. Oh, there's another one. Oh, they didn't finish. There's another meeting. Sorry. Marley, y'all keep cussing in here. I'm gonna beat y'all tail. Y'all hold y'all tongue.
Ashley Falk, number 247452. Is that you, sir?
Yes, sir.
My name's Scott Manning. I'm a hearing officer with the Board of Pardons and Parole, and I'll be conducting today's hearing. I'm going to be taking testimony from you. If you'd raise your right hand, I'll swear you in. Do you swear that the testimony you provide today will be truthful and accurate?
Yes.
Thank you. Did you receive at least 7 days written notice of today's hearing along with your blue disclosure packet?
Yes.
I think as you understand, that disclosure packet is the new information that the board has received since your last hearing. Part of the purpose of today's hearing is to allow you to point out any errors or inaccuracies in that disclosure. Really what I'm planning to do, I'm going to give an overview of what's happened leading up to today's hearing. And I have some questions for you really about what's new since your last hearing. Then at the end of the hearing, I'll give you the final word and you can state anything else you'd like to. But at this time, are there any errors or inaccuracies with the disclosure you'd like to talk about with me?
No, sir.
All right. Looks like you arrived at the prison in February of 2022. You're serving a maximum aggregate sentence of between 0 and up to 10 years in prison. I think there's 9 separate cases. There are 12 felony 3s, all 0 to 5s, but various were entered concurrently, consecutively. As of now, our case analysts have that listed as a maximum of 10 years. The facts of these cases have been discussed at past hearings, so I'm not going to be going over those facts with you again today, but I'm familiar with what happened in those cases. The board will consider those facts. So if you have comments about those, certainly we can talk about them today. Your guideline calls for 39 months. Looks like that guideline passed on September 3rd of 2024. Obviously, the board is not bound by the guideline. They consider your case as a whole in making decisions. As far as their past decisions, looks like May 22, they did a smart scheduling order. They set an original hearing for April 23. They said they expected substance use treatment completion and CAP compliance. I think at that time, your guideline was September 23. You had an original hearing in May of 23 for the 2021 and 2022 cases. After that hearing, I think there was a pending case. Then you had a rehearing, original hearing, November 9th, 23 for that case that was pending. After that hearing, the board scheduled today's hearing. They noted an expectation that you complete substance use treatment as evaluated to be appropriate. I think you were in maximum security at the time, restrictive housing. I think getting into Gen Pop was the step one there, having no disciplinaries, etc. So I have some questions for you about what's happened since the last hearing, but wanted to give you a chance to speak first. What would you like the board to know? What would you like the board to know, or what's new since last hearing?
What's new is I'm out of max. I'm in Dare to Soar program, which is a drug program. I'm doing classes such as CBT, MRT. I am also doing I'm just a bunch of classes. Sorry, I forgot the name of the class, but
it's okay.
I'm also in welding. I'm doing carpentry. yeah, just, I've really opened up my, the doors to succeed this time.
Okay. Yeah, I know it. I think you started Garfield in October 24, CBISU, MRT, and then is that the construction class? You're doing welding and carpentering as part of that construction class?
No, those are just separate. Those are separate. So the classes that I take are Dare to Soar is the main program, and then there's a CBT, which is cognitive behavioral thinking. Then there's MRT. I don't know what that stands for.
Moral reconnaissance therapy, I think.
Yeah. I'm in that, and then there's there's just a couple other classes. I keep forgetting the names of them, but
that's okay.
During the Dare to Soar program, there's other classes in them that
this kind of you progress over time with it. And my understanding is it's a 6 to 12 months IOP. Is that right? Do you have any idea as far as have you talked potential completion dates?
Yeah, so I should complete in April 16th.
Okay.
And I think on my board packet it did say participation. And so I'm just letting you know that. I don't know if it matters.
As far as their expectation, certainly they may have used different wording, and after today's hearing, really the board will consider everything as a whole and decide. They may require you to complete the program. They certainly don't have to do that. They have discretion in doing that, but I'll note that just to make sure that that's accurate. I did. Generally, what have you learned in these classes? Certainly the progress that was expected, you've done, right? You got out of max, you've gotten to the county. It seemed like, your write-ups continued for some. I think you had 2 write-ups since the last hearing, but both of them happened at the facility in Salt Lake. Nothing since the jail. What have you learned over this, in the program or since your last hearing?
What I've learned is that I put myself here. I have no one else to blame. All my crimes are due to my addiction, and I've noticed the addiction is my worst downfall, and I've just come to realize that once I take responsibility for everything I've done, then I can move on, and it's time to take responsibility, and it's time to change that life, because this is not the life that I want to live. Being in here is it's just not where you want to be, and so all these classes made me realize that all my faults and my thinking have been due to my drug habits. And
Okay. I think one of your write-ups, September 24, it was 8/13. I think you tested positive for Suboxone when you arrived at the jail.
That is correct.
Thinking back on that, you've said addiction is kind of at the heart of things. It's a risk factor related to your past cycles of behavior. What do you think led to that? Choosing to use Suboxone at the facility. What coping mechanisms have you developed to be able to, react differently to situations? What insight have you gained since you've been at the county?
In the prison, it's flooded with the Suboxone, and not that it's okay to do it because I'm not prescribed or anything like that, but the thinking was I wasn't ready to change, and now that I'm here, I'm ready to change, and the process of accepting that I had a problem was the biggest step for me, and I just don't have the urge to do drugs, and if I get a craving, they teach you if you get a craving, there's some steps you can do, like step back and take a breath, or talk to support systems, I've been working on that, so that's actually helped me a lot.
Okay. And your other disciplinary, the new disciplinary, was it July 30th, 2024? This one just said you were in a housing section you weren't, a section you weren't housed in. Mm-hmm. What happened there? Why'd you go into another section?
Yeah, it was I shouldn't have done it. I stepped in to talk to someone and I got caught. I knew the rules. shouldn't have done it, you know, yeah.
Okay. Well, certainly, you know, if you're granted parole, disciplinaries, violating rules can lead to a rescission. If you get on parole, not obeying the rules, not abiding by conditions, not appropriately using those coping strategies that you've discussed, really is going to lead to similar patterns of behavior that we've seen in the past. So if you're granted parole, released into the community, thinking back on, you know, your time that brought you here, what do you plan to do differently, applying those things moving forward?
Really, I need to just step away from everyone that I was around, or everyone that I lived with, or thought that I was helping me. I need to go out there and do for myself, because no one's going to be out there to help me. I need to really just take everything I've learned in here and apply it to my everyday life. Because before I came to prison, I was doing really good. And a couple years before I came to prison, I had things happen in my life where I gave up on myself, and I just need to not give up. And I mean, life's going to get hard, but you just need to have a good support system and apply yourself out there, you know. And drugs is not the case. It's not what helps us. It puts us down. So that's what I need to really remember.
Okay. Yeah, the jail staff in Garfield there provide a positive report of your behavior and attitude since you've arrived at the jail. I'll note that for the board. I've taken some notes about your release plan. I think, you know, living with your sister, work, etc. So I've got some notes on what you submitted. Thank you for taking the time to write those things down. It helps me as I'm preparing and providing information to the board. But want to give you a chance today. If you are granted parole, what would your release plan look like?
So I've changed that. I wanted to go to Vegas to be with my sister, but the more I'm in this program, it teaches you to be around people that you can be around and thrive. And I don't think my sister right now is the correct person to live around. So I've actually called a sober living and / program, and they've accepted me. They're holding a bed for me. It's called 7th Street. So they're going to put me in as soon as I get accepted. If I get immediate release or whenever I get released, they'll have a bed, and I do a 3-month program. And after the 3 months, I'll move into sober living. And from there, I mean, I really need to get out so I can pay all my restitution and get a job and get back into the niche of life. But yeah, moving to Vegas is not an option anymore. It's I just come to the conclusion it's not probably the best place to go, having an addictional life. So I'm gonna stay here and keep my sobriety life moving.
Okay. Yeah, I agree. I think a transition program, sober living type facility, that seems like a good plan, something positive to do. It takes me back to, because I think you had probation prior to prison. First step, you were there and absconded. Certainly, I think in our minds, having that program is the ideal. Once you get there, you realize sometimes things aren't perfect and there's challenges that arise. Thinking back on the programs that didn't work on probation, how can you approach things differently so you can have a positive outcome?
Well, the program prior that I ran from was First Step. They had no open door policy. I was in a relationship that wasn't healthy. And so that relationship made me want to run. And, you know, I'm not in that relationship anymore. So I don't have an excuse to run, or I don't have a reason to not continue my sobriety. You know, it's I'm going to surround myself with clean and healthy people. So that's my biggest key.
Okay. As far as work, temp agency, try to work to get something more stable, but take kind of what's available to you up front. Is that still the plan?
Yeah, I'm gonna whatever's available, but I really am stepping into excavation. I did that for many years before prison. And so I'm good at it, and I know there's always work for that. So I'll start from the bottom wherever I need to and work my way up and pay all my fines and restitutions and, you know.
Okay. And are you still active STG?
I am.
I think if you're granted parole, it'll include gang conditions. Obviously, not associate with known gang members, have in your possession gang-related material, be in places where gang members associate, or etc. Are you willing to abide by those conditions?
I am. If I can speak on that, so being in prison, it's I've joined a gang, but it's a prison gang. Really, it's everything in here happens in here, and when I'm out there, I'm gonna apply myself to myself and really stay away from anyone that would cause me to come back. So if I need to stay away from the gang to better myself, then I'm 100% into that, you know?
Okay. I'll note your comments for the board in that regard as well. I think you also provided some written thoughts on that I've put into a report at this point. Those are the questions that I have for you. What else would you like the Board of Pardons to know?
That I've accepted that all my crimes was due to myself, and I'm ready to change. And I apologize to everyone that I've ever hurt. And I hope I can be released soon.
All right, what I'll do from here is take your case under advisement. I put together a report of what I reviewed before today's hearing. I'll include what we've talked about at today's hearing in that report, and then I'll submit that to the members of the board, hopefully by tomorrow. As you know, there's 5 members of the board. They make decisions by majority vote. Usually that takes a couple weeks. Sometimes it's a day, a few days. Sometimes it does take a couple weeks. Once the decision is made, we'll send it to you in writing through the mail, and it will also be posted to the board's website if there's anyone in the community that would like to access it there. So with that, Mr. Falk, thank you for being here and discussing these things with me. Wish you the best of luck moving forward, and we'll go ahead and conclude.
Thank you.
Do y'all think he's gonna get out? Yes or no? Yes or no? Do y'all think he's getting out? I think he is. He's waiting on another person, or he's done for the day? Is he frozen? Is he moving or frozen? Oh, he's done for the day, y'all. Oh, no, he's not. He's not done for the day. All right, y'all. This has been like really fun. I need to get off this live because I got calls coming in. Because I got stuff to take care of. I've been sitting here with you guys all day long, and I need to go take a moment's snooze, a little, try to get my stuff together, because tomorrow I go home after court. So I need to get all my stuff. I don't want to forget nothing in here. You know, be prepared. Oh, he muted again. I need to get my stuff so I can fly away. Go outside, make sure my car is gassed up. Be ready to go. Yep. Be ready to go. If I find out there's no court tomorrow, I'm gonna leave straight in the morning time. But most likely it'll be court tomorrow. Let's see if we get one more person in here, and then I'm out. I gotta take this We can't hear you. Put it back on. You make it home. One fill up. Yeah, one fill up. I make it home. Yeah, one fill up. I'll make it home. Just gas up, and then I go straight on home. One fill up. Yep. It really felt pretty good.
This is an original hearing for Jace Crook, number 242772. Is that you, sir?
Yes, sir.
My name's Scott Manning. I'm a hearing officer with the Utah Board of Pardons and Parole, and I'll be conducting today's hearing. I am going to be taking testimony from you today. If you'd raise your right hand, I'll swear you in. Do you swear that the testimony you provide today will be truthful and accurate?
Yes.
Thank you. I do want to recognize victim of record, Sadie Jones, who we have here with us in the hearing. She will be providing testimony in just a few minutes. Thank you for being here, Sadie. I'll let you know when we're ready for that statement.
Sadie's here. Thank you.
Mr. Crook, did you receive your at least 7 days written notice of today's hearing along with your blue disclosure packet?
Yes, I did.
Okay. I do want to note that today, just this morning, the Board of Pardons and Parole received from the Department of Corrections a sex offender treatment program discharge summary dated January 9th of 2025. It was prepared by Mr. Jared Hill. Based on what I'm seeing in our records, we sent a copy of that to you just today, recently. Did you receive that document?
I received it yesterday, yes.
Oh, you received it yesterday. I didn't get it till this morning. So you got it yesterday. So you have the right to receive and review that document with sufficient time. We say a week to be prepared to talk about it. If you'd like to, we can postpone today's hearing to give you further time to review it. Or if you're willing to waive further disclosure, we can proceed today. How would you like to waive disclosure? Okay. And part of the purpose, so that blue disclosure packet, along with the sex offender treatment program discharge summary, that's the information that the board will be considering as they make a decision in your case. I'm planning to go over much of that information with you. So basically, to give a rundown, what I'm going to do is start by giving an overview of your case. So your conviction, sentence, your guideline date. We'll talk about how today's hearing works. After that, I plan to review the case in which you were committed to prison. We'll briefly talk about what happened in that case. From there, we'll have the victim impact statement, and you will be able to respond to that statement if you'd like to. After that, I have some questions for you about what you've been doing in the facility, your plans moving forward. And then at the end of the hearing, I'll give you the final word and you can state anything else you'd like to. But part of the purpose of today's hearing is to allow you to point out any errors or inaccuracies with that blue disclosure packet that we sent to you. At this time, are there any errors that you'd like to discuss with me?
No.
Okay. Your commitment offense is rape, felony 2.
Ooh.
You're serving a sentence of between 1 and up to 15 years in prison.
That's it?
As of now, that sentence will expire on February 4th of 2035. So that is the maximum amount of time that the board retains jurisdiction over your case. Your parole guideline calls for 64 months. That is established by the Utah Sentencing Commission based on your conviction, your criminal history, a few factors that go into that. That's a recommended release date. According to that guideline, you would be released on June 4th of 2025. The board is not bound by that guideline. After today's hearing, they will consider your case as a whole with all relevant mitigating and aggravating factors to decide if a release is appropriate, and if so, the timing, conditions, contingencies of any such release. I do note that in February of 2022, the board did what's referred to as a SMART scheduling order. At that time, they scheduled today's hearing. They asked for a sex offender treatment program memo. They noted an expectation that you complete all available and recommended sex offender treatment and substance abuse treatment as well. Excuse me.
He's eligible in 2025.
And it looks like in January of January 21st, 2025, so 2 days ago, the board recognized an earned time credit because you did complete the sex offender treatment program. So that brings us to today. The case we need to talk about is case 191100614. In the pre-sentence report, it contains the official summary of that case. It says in February of 2019, the victim reported that you had raped her in July of 2018. At that time, you were 22 years old and the victim was 14 years old. The pre-sentence report summary of the case says that your girlfriend was in the shower and you entered the victim's room. You touched the victim's side and took off her clothes. You then took off your clothes and told the victim not to tell anyone. The report says you raped the victim and then left the room. The pre-sentence report says another incident occurred while you were camping as well. The pre-sentence report seems to describes these two incidents as vaginal intercourse. The report says the victim's mother confronted you about this and you admitted to having sex with the victim, quote, but stated it was not rape. I've reviewed your pre-sentence report statement as well as your statement that you provided in the Board of Pardons packet to us, but is that summary that I just provided for you, is that accurate as to what happened in the case?
Yes.
Okay. And what led to you engaging in this behavior at this time?
I was immature and I wasn't thinking about my consequences or the whole ripple effects that it could have caused, which I know now.
What? That's your excuse?
How do you mean? What do you mean by ripple effect or the consequences? Can you expand on that any further?
Well, like the whole impact it had on my victim, on Sadie, and her family, and also what it did to me and where I've been, how I've been incarcerated for 5 years, the impact it's had on my family from the choice and the decision that I made, the trauma that I could have caused.
No, that you caused, not could have, caused.
Okay.
So 5 years plus 4, she's 19 now.
Okay, at this time we'll move forward with the victim statement. Sadie, are you prepared at this time to provide your statement?
Yeah, I'm ready.
Okay, thank you. If you just, so you don't have to turn your camera on, but if you raise your right hand and let me know when it's raised, I'll just swear you in quickly.
It's raised.
Do you swear that the testimony you provide today will be truthful and accurate?
Yes.
Thank you. And again,
Hi.
thank you for being here. I have reviewed the input provided at sentencing, I believe from a family member of yours, but I appreciate you coming to today's hearing to provide input. I'll take notes of your statement. I'll probably listen to your statement tomorrow and make sure the board members are aware of your thoughts and feelings as they consider this case. So you may proceed when you're ready.
The situation that happened when I was 14, and with it happening twice, and the way that my parents went about it really impacted how I struggle with building relationships and with like having relationships with men, and it gets very overstimulating for like physical touch and things like that. But after hearing like the programs and everything that Jace has been working on, and I don't really feel, the only concern I have with if or when he gets out and is free is there were threats made by his ex-girlfriend, and I'm just not sure. I haven't been feeling very like safe, and I've been feeling kind of like nervous about this whole thing going on, but it sounds like Jace has been putting in a lot of work and
Wow,
been
she's
doing
forgiving.
what he needs to do, and I believe that people can change, and that, you know, I've made mistakes before too with just like not thinking in the moment, but
Okay, girl. You're forgiving.
it has definitely impacted me, but I do believe people can change over time.
Okay, young lady. She forgiving you.
That's all.
Please forgive.
Again, thank you for being here and providing input. The board does value your input and your feelings that you've provided. Thank you again for that. And Mr. Crook, would you like to respond to that statement?
I would like to agree with her, and I'm thankful that she has noticed and is open-minded to knowing that people can change, because who I was to who I am today is completely different. And I'm just glad that she was here to say what she had to say.
Okay. While at this time, I was going to bring this up a little bit later in the hearing. If you are granted parole, if and when that does happen,
he's going to get
it
parole.
will almost certainly include what are referred to as Group A sex offender conditions. There are various conditions that are involved in that, including completing recommended treatment, submitting to random polygraphs, having residences and jobs approved, not associating or contacting children under the age of 18 without proper approvals. Part of it as well is having no victim contact without approval from your supervisors, and that includes indirect or direct contact. So anyone contacting on your behalf or from you to a family member or anyone associated with the victim would be a violation of that condition. If you are granted parole, are you willing to abide by those conditions?
Yes.
Yes.
Yeah, he gonna get out, y'all.
All right, so since arriving at the facility, looks like March 2021, you've successfully completed impact of crime, anger management, and the sex offender treatment program. What have you learned in those programs and classes?
Anger management, I learned how to manage my anger in a healthy way, to stop and think about, the consequences, and instead of just acting out and not thinking about like the after effects, I really sit and
I do not
think it's something worth it if I were to act on it. And impact of crime has made me realize the whole impact and ripple effect that you can have on somebody's life by making a split decision without thinking about the after effects of that as well. And then pre-SOTP taught me to be accountable for my actions and to not use minimizations or anything like that when it comes to talking about your situation and your case. And CORE has taught me a lot more about how to respond to high-risk situations and what to do if you're found in one, how to respond to people in a positive way, how to recognize people's movements and their body tone, their body language, about like stopping and thinking before you act on something. Also to what's the word I'm looking for? It's like to reflect on something. So say I'm in a risky situation, that say something in my past, like back when I was catching drug charges all the time. I could reflect on those things if I got into those thinking patterns again, and I could pull myself out of it just by recognizing.
Thank you for your comments. I'll note those in my report to the board so they're aware of them. Looks like you've had various disciplinaries. I think one, March 14th, 2022 is an A13. You possessed homemade alcohol. Were you using homemade alcohol at that time?
At that time, I was a little bit, but it was more of a situation where someone had me hold something for them.
Okay, when's the last time you used drugs or alcohol?
Last time I used drugs or alcohol would have to have been, I'd say, over a year ago.
Okay. I note that I think your history at the time of this offense and leading up to this offense, some substance abuse and drug distribution was going on. Do you view substance abuse as a risk factor in your case?
No, not anymore, because so most of my problems were with marijuana, and I do have mental disabilities and stuff that when I use marijuana, it helps. But now that I can get a medical card, and I'm not into anything harder than marijuana, so I don't see it being an issue. I don't have the temptations to want to go back and sell marijuana either, because it did me no good in the long run. Yeah, it's fast cash or whatever, but it's not an honest way of living, and I don't want to do that anymore.
Okay. I think the board did previously set the expectation of you completing substance use treatment. After today's hearing, they could make an order and require you to complete that. They could also allow you to do any recommended treatment in the community. Really, it's up to the board, but are you willing to do that treatment if it is ordered?
If I have to, yeah. I mean, I have completed every single drug test I've ever been given since I've been incarcerated. I have no failed UAs. Back in 22, I went to Hope, and the therapist that was supposed to put me in the program, she did an assessment on me, and that said it was completed when I looked at the blue packet.
I show you did an assessment in 2022. It recommended residential treatment, but you've not done any substance use treatment. Am I reading that wrong?
I believe you're correct.
Okay. Yeah, so it's up to the board after today's hearing, certainly if they decide that is a requirement or not. But I just wanted you to be aware of that and get your input on that. I do note there was a write-up. So July 16th, 2022, the second, looks like you went into another inmate's cell. Do you remember that incident? So you just went into someone else's cell and sat down. Is that accurate?
Yeah, that was over in Ironwood. I have quite a bit of write-ups in Ironwood because it was kind of set up a little bit different than the other places in the prison.
Yeah, the August one, I think you didn't rack in immediately when an incident started. And then again in August, some interaction with an officer about shutting a door. June 2023, B16 tattoo contraband. Were you tattooing, or were you holding that, or what happened in that incident?
I was getting a tattoo.
Okay.
And then the one for fighting and assault is actually a horseplay. I didn't have
BO2?
Yeah, I never got in any fights the whole time I was in prison.
Okay, so BO2, it says you guilty charge when, quote, I saw you, an officer saw you trying to pick up, wrapping your arm around another inmate. Your statement is that was a horseplay right up with your cellmate. What happened here?
So that was with my buddy Kenny. His name's Kendall Larson. And we were kind of just messing around, wrestling a little bit. We weren't serious or anything, but Officer Woodmansey saw it, and he was not a officer in our section or anything or on the unit. He was just doing pill line. And so when he glimpsed and he saw that, he called an IMS because he thought we were actually fighting.
Okay. I'll note your comments on those incidents. I know the report from the county jail is positive. It says you've been well behaved, no negative issues, seem to get along with staff and other offenders. You're an SOTP, engaged in therapy appropriately. It lists various jobs that you've had, gives a good rating in all your jobs as well. So I'll report that for the board. So the SOTP summary, I just got it today. Looks like it identifies using the standard risk assessment tools, the static 99R, stable 2007, It identifies a well above average risk of reoffense. It goes over statistics regarding what that means and the demographic in which you fall. It gives a positive report, looks like, of your attitude during treatment. Talks about some of your continued care plans as well. Based on your risk assessments, it details some of the things you did in treatment with risk factors, coping strategies, etc. Recommends that future treatment focus on maintaining appropriate long-term romantic relationships or dealing with your history of struggling with that. Building protective factors such as intimacy with adults and engaging in meaningful romantic relationships. Talks about your past struggling with feeling included in social groups and engaging in pro-social leisure activities. It talks about a history of using sex as a way to solve social and emotional problems. Says you'd likely benefit from treatment that will help improve in those specific problems and cope with life stressors in healthy and sustainable ways. Notes that you successfully completed the program. And it recommends that you be evaluated for the possibility of parole at today's hearing. Do you have any other questions or concerns about that document? Do you agree with what it states or any opinions that it gives?
I agree with it.
Okay. So I've reviewed your written submissions about your release plan, have some notes about where you plan to live and work, the treatment you'd like to do. Thank you for providing those before today's hearing. It helps me prepare. I want to give you a chance today. If you're granted parole, what would your release plan look like?
My release plan, my short term would be when I get a date to get my address verified and approved. And then also my work. So I work for my stepdad, tying rebar for the union. And I've been doing that before I ever even got incarcerated. So I do have a career doing that. And then just get in touch with my parole officer and all that. And then for my long term, I'd have to do after care, of course. I have to do some more programming when I get out for 6 to 8 months. And I'd like to get that going as soon as I get out too. And then get my medical card so I don't have any problems there. And then long term would be start saving up money, finish aftercare, find my own place, get it approved, just rebuild my life.
And you're planning to do aftercare with Alpha? Is that still the plan?
There's an Alpha over in like Linden area, I believe, and I was gonna contact them and see if I can get on schedule with them.
Okay. Certainly providers are available. I would recommend, if you're granted parole, talk to your agent. You can talk to your case manager leading up to that, have things arranged as are appropriate. I've read some documents regarding mental health from the time of sentencing, the court order that led to the prison commitment. What are your diagnoses as you understand them?
I was diagnosed with learning disability. Is like I'm a slow learner. I have problems catching on to things sometimes, especially math. I have ADHD, and I've been diagnosed with bipolar type 2. But ever since I've been incarcerated and I've been working on my mental health and my physical health, I pulled myself off of mental medications by working out.
Okay. At times, the board will include in a parole agreement what's called mental health conditions. That requires a mental health evaluation and then complying with any treatment that's recommended. Certainly, even if that weren't to be needed right off the bat, if there were struggles that happened, if things occurred, it's something that can happen as well. Do you think that would be a good idea in your case? What are your thoughts on that?
If that's what they want to do, I will comply with that.
What are your thoughts on it? Do you think having mental health treatment, meeting with someone in therapy, I know obviously the board makes the decision on what you'll have to do, but I'm interested in what you think. Would that be helpful to you?
I personally don't think I need any medical or mental health analysis or any evaluations. I feel like I'm under control myself, you know.
Okay. Well, those are the questions I have for you. What else would you like the board to know?
I would like the board to know that I take accountability for my actions, and I do feel bad for what I did, and I just wish I could move forward with my life.
Okay. What I'll do from here is take your case under advisement. I've put together a report of what I reviewed before today's hearing. I'll include into that report what's been discussed at today's hearing. I'll then submit that to the members of the board, hopefully by tomorrow. There's 5 members of the board. They make decisions by majority vote. That usually takes, we say, up to 2 to 4 weeks, but sometimes the decision is made in a few days. Sometimes it does take a number of weeks. Once the decision is made, we'll send it to you, Mr. Crook, through the mail, and it will also be posted to the board's website if there's anyone in the community that would like to access it there. So that's how we'll proceed. And with that, thank you to everyone who's participated in today's hearing. I wish you the best of luck moving forward, and we'll go ahead and conclude.
Thank you.
Thank you.
This is an original hearing. Is it Anatoly Boardman?
That's correct.
Number 248761. Is that you, sir?
248761.
Correct.
Yeah, that's me.
My name's Scott Manning. I'm a hearing officer with the Utah Board of Pardons and Parole, and I'll be conducting today's hearing. I am going to be taking testimony from you. If you'd raise your right hand, I'll swear you in. Do you swear that the testimony you provide today will be truthful and accurate?
Yes, I'll testify that.
You will tell the truth today?
Yes.
Okay, thank you. You can lower your hand. Did you receive at least 7 days written notice of today's hearing along with your blue disclosure packet?
I did.
So that disclosure packet contains the information that the Board of Pardons will be considering as they make a decision in your case. I'm going to be going over quite a bit of some of that information with you during the hearing. But part of the purpose of today's hearing is to allow you to point out any errors or inaccuracies with that disclosure. Excuse me. Before we move forward, are there errors or inaccuracies you want to discuss with me?
Not right now.
Okay. What I'd like to do today, I'm going to start by giving an overview of your case. So we'll talk about your convictions, your sentences that you're serving, your guideline date. I'll basically tell you how today's hearing works. From there, there's 2 cases in which you were committed to prison. We'll briefly talk about what happened in each of those cases, the facts of the cases. From there, I have some questions for you about what brought us here today, what you've been doing since you arrived at the facility, and your plans moving forward. Then at the end of the hearing, I'll give you the final word, and you can state on the record anything else you'd like to. Does that sound okay to you?
Yes.
Looks like your commitment offenses are unlawful sexual activity with a minor, felony 3, and tampering with a witness, felony 3. You're serving a maximum aggregate sentence of between 0 and up to 5 years in prison. As of now, that sentence will expire on February 16th of 2027. So that's the maximum amount of time that the board will retain jurisdiction over your case. That's when your sentence will run out. your parole guideline calls for 33 months of incarceration. Based on that guideline, you would be released on November 16th of 2024. The board is obviously not bound by that guideline. It passed on November 16th of 2024. In making decisions about release, the board considers your case as a whole to determine the timing of a release, and if so, the conditions, contingencies of any such release. Looks like in January of 2023, the board scheduled a November 2024 original hearing. They requested a sex offender treatment program memo, and they said they expected you to complete the sex offender treatment program and comply with your case action plan. Looks like you had an original hearing on November 26th of 2024. I think you had not received your institutional progress report, so you requested to have the hearing continued or rescheduled. So the board did continue the hearing and schedule today's hearing so that we can proceed with the hearing. So the case we need to talk about is case 2011-00764. The first case looks like in April of 2020. I think you were 20 years old at the time. You began speaking with a 15-year-old female victim on social media. You told this victim you wanted to have sex with her. You arranged to meet at a park. You then went together to her house where you ate and watched a movie. The report says you touched the victim's vagina and breasts with your hands and mouth. Later, you sent the victim sexual messages. You sent nude videos to the victim. The report also says you would force the victim to take off her, or make the victim take off her clothes and touch herself. It says that this made her uncomfortable and she felt like she had to do it to please you. The official version of the case also says that the victim knew a separate 15-year-old female with whom you had exchanged nude photos and videos in a similar way. Is that accurate as to what happened in the case?
No.
So what happened?
So the part that you said about taking, like me telling her to take the clothes off, I never said that.
But you admit you met this 15-year-old female on social media, arranged to meet up with her and engaged in sexual activity with her. That's accurate?
Yeah, that was accurate.
Okay. And what led to you engaging in this behavior?
Well, she asked me out and we started dating, so like boyfriend and girlfriend.
Boy, really?
You said she asked you out and you started dating. Is that what you said?
Well, she sent me messages on social media and we just started talking, and then she asked me to be her boyfriend. And then after a while, like we started dating. And after that, that's what happened.
Did you know she was 15 years old?
At that time, I didn't.
You did not?
No.
Did you suspect she was underage or 15 years old?
Yeah, assumptions.
Then why you date her, dummy? This dude's
Okay, so having assumed or known, suspected that this individual was 15 years old, why did you pursue a sexual relationship with her?
good question.
What led to that?
I don't remember. Like, I don't know.
Have you gained any insight into that as far as what led to that behavior?
What do you mean?
So that's the reason we're here. That's a felony offense in Utah. You've been convicted of that. I'm trying to glean any insight into that. Do you regret doing that? Do you recognize that it's wrong? That's something that you should not do. Any insight at all about the case?
Yeah, I regret. And since I've been down, I did programming, and I knew when I've been in prison, I've been thinking about it, and it was stupid of me doing it, and I was young at the time, so I was not.
How old is he?
Like, thinking with my head straight, and yeah, I was 20, and I should thought better of that.
He was 20.
But I was dealing through a lot. I was homeless, and I was just going job to jobs, and yeah, I was not thinking at the time.
He's slow, y'all.
So earlier, you said the victim asked you out. The victim asked you to be her boyfriend. Really, the issue here is that you were 20 years old and this was a 15-year-old minor. So I just want to be very clear. You would agree that it is inappropriate for an adult to engage in sexual behavior in any way with a 15-year-old minor. Is that something you agree with?
Yes, I agree to that.
Okay. The next case is case 2011000892. Looks like August of 2020. You sent, the report says, quote, suicidal messages to that victim, asking her to drop the charges. I think it says you sent a photo of yourself holding a knife to yourself at that time. Is that accurate as to what happened?
Jesus.
Yes.
Lord have mercy.
Walk me through your mindset with that, certainly reaching out to a victim in this regard. What led to you engaging in that behavior?
Well, because I was dating a different girl at the time, and she went on vacation, and I told her about the situation, and she told me, like, can you ask her to drop the charges? And I listened to her, and that's what I said to this girl, to drop the charges.
Oh my
You're
Lord.
saying someone else told you to reach out and do this? Is that what, did I understand that correctly?
Yeah, somebody told me, like,
He
can you ask
was
this person to
20
drop the
then. He's
charges?
older now.
That's what I did.
Tanya. Natalia.
But you were the one who did that, right? So walk me through your actions. What have you learned about, obviously that's a violation of reaching out in that way to the victim. That's another felony conviction for tampering with a witness. What insight do you have about what led to you engaging in that behavior? Any insight about coping strategies to change that? Have you gained any insight into that?
Well, I'm thinking about it. At the time, I didn't know what is tampering with a witness means. And now, I do what's tampering the witness, and you're not allowed to, like, go to a victim and ask them to drop the charges when you're doing a crime. So now I understand very clear.
He didn't understand it then?
Never gonna do that again.
Dude.
Okay. Looks like you were placed on probation in these cases in November of 2020. I think your conditions included standard conditions, substance abuse related conditions, maintain employment, and group A sex offender conditions, which obviously include doing recommended sex offense treatment, no contact with any victims, no contact or association with children under the age of 18. Looks like you were unsuccessful in sex offender treatment about a year into it. I think the report I reviewed says there was, due to your attitude in treatment, you did not get back into another program, I think a private program you were supposed to get into. I think the reports discussed at times working on and off, but having kind of struggling to maintain that. I think probation was restarted in January 2022, and the judge ordered that you complete the treatment program. And I think you had the violations for going to Wendover. There were speeding tickets there, and then officers found pornography. You'd been viewing pornography on your phone.
Oh my.
And I think you had messages, something about dating an individual with siblings in the home under the age of 18. I think those are the violations that led to prison. Is that accurate?
Yeah, that's accurate.
Dude.
Okay. And I think you were attempted theft of services, misdemeanor B conviction from October 2021. So I guess, you were given a chance at probation prior to prison. The goal of that was for you to address your risks, your needs related to this behavior that led to these convictions. And you struggled to do that on probation. What do you think prevented you from being successful while you were on that probation?
Well, because I have gambling addiction, and I like to go on Wendover. And like when I had a job, I usually get a paycheck, and instead, I was homeless too. And then instead saving money for apartment or keeping a apartment,
Yeah,
I just go to Wendover and I gamble. It's like just pass the time.
I mean, obviously, if you're on probation and if you're on parole, if the board were to grant a parole, you can't leave the state without permission, right? There's rules, there's regulations you need to follow. What insight do you have into that? I mean, are you at a point now that you're willing to comply with those things, or what do you think needs to be different if you're granted parole so that you can be compliant and successful?
Yeah, if I will grant to parole, I will comply with our regulation and our rules 100%. And if I wanted to go to Wendover, or if I want to do something, I would communicate with my parole officer.
Looks like you successfully completed the pre-sex offender treatment program, but you were unsuccessful in the sex offender treatment program, the core portion. You were removed in August of 2024. What happened in the program?
In pre-program, I got kicked out once because it's pretty hard for me to do like the program over here. And I restarted the pre, it took a year to finish the pre. I think I got kicked out on book 5. There's book six books on pre, and I kicked out on book 5. And then for like 30 days, and I restarted again in 2023. Yeah, I think I restarted 2023, and I finished in 2024. And I went to court August, I think August 2nd in 2024, and I lasted like 3.5 weeks, and I got kicked out again. And now I'm just,
Yeah, so that, I mean, I have all the dates. I know that you were removed at those times that you recently removed. Why were you removed? Why were you not able to complete the program? What happened?
Because in King County, I was in court, and I called somebody, you're a different caller, and they called me out I was racist, which is I wasn't, and that's the reason they kicked me out. And then they also called me out I was cheating, copying people assignments, and getting their examples, and I don't know, they're just being pretty strict over there. So yeah, they just, I don't know, they just kicked me out because they're hating me.
Okay. We received, the Board of Pardons received a sex offender treatment program discharge summary. It's dated August 30th of 2024. It was prepared by Mr. Guy Finicum. Did you receive a copy of that document?
I did.
Okay. What are your thoughts about that document?
No, they put me like they sent me a letter and then told me to write to Green if I want to do the core program. And I came here, and this jail has been like making me depressed, and I don't know, it's been different over here. So like I just don't know, like I think it would be better doing the program on the streets, like if I pay with my own money, and instead over here, because if I do over here, I'll be honest with you, I'll get kicked out, and I probably like won't finish it the core. So like my best option would be doing like on the streets instead over here.
Yeah, I read that in your written submission that you sent to us. The issue that I'm seeing with that is that you were given the opportunity to do it on the streets on probation multiple times, and you kind of ran into what seemed to be similar issues, right? You weren't able to progress due to your attitude in the program, not progressing appropriately. If the board were to allow you to complete the treatment in the community, what would be different? Why would you progress appropriately there?
Well, because I would have a job first, and then I won't be around criminals, because over here, like, it's hard for me to do the program because it's like, I don't know, like I get judged over here, like I just get mad and I just give up over there. Like I'll be by myself, I have a place, a job, money, and I would come like once a week. I don't know if they do like once a week, like program. I'm just going over there once a week, and I should finish like in a year.
Yeah, I mean, any programs take a year and a half, but really the point of that is you have to progress, and it's not checking a box, going to a class. It's trying to address the issues that you have. To that regard, the risk assessments in the document based on the static and the stable assessment that is provided. Let's see. It provides places you in the well above average risk of reoffense using the static 99R and the stable 2007. It does recommend, based on those assessments and based on your poor performance during the treatment that you have done, that you complete the program prior to release. Okay. Any other thoughts about that document? Thoughts about the treatment, what you've learned? You've talked a lot about what happened in the program, that you weren't able to complete it. What have you learned as far as coping strategies, how you can change your behavior moving forward?
I don't know. I still didn't think like are you asking me if I'm gonna gain a program over here or on the streets, and what coping skills I'll be using?
What was that? Did you ask me? What was the question?
Yeah, the question is like if I'm gonna do the program here or on the streets and what coping skills I'm gonna use.
Yeah, I just, the goal of treatment is to develop coping strategies. The assessment tools identify an above average risk, well above average risk in your case. Your treatment is designed to develop coping strategies so that you can change your behavior to address the risk factors that you deal with. Do you have any insight about how you'd plan to do that if you were released into the community?
My coping skill would be just go to the gym, listen to music, and I don't know, writing songs or like playing an instrument or just talk to because I have anger issues. Like then I'll just do like counseling, therapy on the streets. Like I don't know, just do all those things.
Okay. I have read your written submissions. If the board were to grant you parole, what would your release plan look like as far as where you plan to live, work, and treatment that you do?
I would have a job and a place, and treatment would be my first priority. And like, if I have a job during the day and they require me to work it and treatment during the day, then I'll just work at night and do the treatment during the day and follow the parole rules. And I don't know, it's hard for me to explain because I'm not really good at like talking. Like, I don't know, like I'll just work and do treatment and I don't know, like it's hard for me to explain. I'm not really good.
That's why we're having the hearing today. So take your time, and I'm here to relay what you have to say to the board. The members of the board after today's hearing will decide whether you'll be granted parole or not. So anything you'd like them to know, this is your time to state it. So take your time.
Sorry, I'm just being nervous. Yeah, so like I just get a job. Like I've been thinking about getting 2 jobs, but it's not worth it because it's like I get depressed, I have depression, and I get suicidal when I get depressed. So like I'm not gonna get 2 jobs. I'm just gonna get 1 job, and I'm gonna work at night and like sleep during the day, like maybe 5 hours or like 6 hours, then do the treatment and do counseling and therapy to help him with my depression, or I'll go like to like clinic or somewhere like because I don't want to take medications because I've taken Prozac before. I don't know if you know what is Prozac, and that didn't help. So like I don't know. I just want to.
You filled out a packet for the board. You said that you've taken medications in the past. I think you said, quote, "The reason I stopped taking them was because I wanted to feel sad." What did you mean by that? What did you mean by that?
Well, because when I was in high school and my family who adopted me, they made me take Prozac. And if I don't take Prozac, I'll get in trouble, like not in trouble, like they give me a consequence. But then when I turned 18 and I just stopped taking Prozac because they make me like feel like I don't know, different, like I make people like I don't know, I don't think straight when I take Prozac. Like I do something stupid that like people don't like it, like, and afterwards I laugh, like I don't know, like I just hurt people, and I don't think, I don't have to explain. Like I was just doing stupid things when I was taking the Prozac. Like I was laughing, and I don't know, I was not saying I'm sorry. I don't know. I just don't like taking that because it makes me feel weird.
And how would you say your mental health is right now?
Right now it's stable. I mean, since I came to this jail, I've been depressed. I've been like sleeping the most of the time. And when I was in Gunnison in Kane County, I was like more active. And over here, I just like, I don't know, my mood swings went down. Yeah. I don't know, I've just been different feelings.
And have you what's your plan about getting back into treatment? Do you have classes, treatment available to you at the county jail where you are?
No, I got kicked out over there, and I don't want to go back there because it's pretty hard over there. Like I only lasted 2 weeks or 4 weeks. Like, yeah, it's really rough, and I feel like if I do go back there, I'm probably not gonna make it. Like I'm not 100%. Like I'm not gonna make it.
So if the board, after today's hearing, says you have to complete treatment before you get released, would you say no? You'd refuse to do that?
I don't know. I'm gonna think about it. I'm not gonna refuse it, but I'm gonna think about it like really hard and decide, like what is best for me.
Okay. Well, those are the questions I have for you. We're just about out of time, a little over time, but want to give you the final word. Is there anything else you'd like the Board of Pardons to know?
No.
Okay. What I'll do from here is take your case under advisement. I've put together a report of what I reviewed before today's hearing. I'll include what you and I talked about today at the hearing into that report. And then I'll submit that to the members of the board, hopefully tomorrow or within the next few days. There's 5 board members. They make decisions by a majority vote. So 3 out of 5 have to agree on what to do. Usually that takes, we say up to 2 to 4 weeks, but sometimes it's a few days. Sometimes it does take a few weeks. Once the decision's made, we'll send it to you in writing through the mail, and it will also be posted to the board's website if there's anyone in the community that would like to access it there. So with that, Mr. Boardman, thank you for being here and answering my questions. I wish you the best of luck moving forward, and we'll go ahead and conclude.
Thank you.
All right, y'all, I'm gonna end this because that's enough. All right, guys. Hold on. I want to see what his is. That's a woman or a man? That's a woman, right? That's a woman, right? That's a woman?
This is an original hearing for, is it Michelle Luke?
Okay, so yeah.
Number 229816, is that you?
Yes.
My name is Scott Manning. I'm a hearing officer with the Utah Board of Pardons and Parole, and I'll be conducting today's hearing. I'm going to be taking testimony from you today. If you'd raise your right hand, I'll swear you in. Do you swear that the testimony you provide today will be truthful and accurate?
Yes.
Thank you. Did you receive at least 7 days written notice of today's hearing along with your blue disclosure packet?
I did.
Okay. Well, that disclosure packet contains the information that the board will be considering as they make a decision in your case. What I'm planning to do today is go over some of that information. So I'll give an overview of your sentence, your conviction, your guideline date, a little bit about how today's hearing works. From there, I think there's 3 cases in which you were committed to prison. We'll talk briefly about what happened in those cases. From there, I have some questions for you about what's brought us here, what you've been doing recently, your plans moving forward. Then at the end of the hearing, I'll give you the final word, and you can state anything else you'd like to on the record. But before we do that, part of the purpose of today's hearing is to allow you to point out any errors or inaccuracies with the disclosure that we sent to you. At this point in time, are there errors you'd like to discuss with me? Okay. Your commitment offenses are 3 counts of retail theft, felony 3. Looks like you're serving a maximum aggregate sentence of between 0 and up to 5 years in prison. As of now, that sentence will expire on November 16th of 2028. So that's the maximum amount of time the board has jurisdiction. That's when your sentence will end at this point in time. Your guideline calls for 14 months incarceration. Based on that recommended release date, you would be released on January 10th or you would have been released on January 10th, 2025. So that passed about 2 weeks ago. Obviously, the board is not bound by the guideline. After today's hearing, they'll consider all relevant factors in your case to decide what's appropriate as far as a release. I do note, I think you were granted 305 days of credit for time served prior to arriving at the prison, which has kind of led to the point where we're over guideline at this time. The first case we need to talk about is case 231501874. Looks like September 2023. You were stopped by police in a Walmart parking lot. I think you had taken some shoes from the store and they were in the car with you. I think you were seen on camera taking those from the store. Is that accurate as to what happened? Second case, 2315-02312, November 2023. Looks like you took about $200 worth of items from a market. I think you put them in your bag and then left the store. Is that accurate as to what happened?
Yeah.
Next case, 2315-02173, September 24th, 2023. I think about $397 from Walmart. You took these items. I think you attempted to pay, card was declined, and then left with the items. Is that accurate?
Yeah.
Okay, I think in your written submissions you sent to us, you said really this behavior resulted from supporting your drug use and your addictions at the time. Do you have any other insight about what led to the behavior in these cases?
I mean, I think that pretty much sums it up. And at the time, like, I knew that I shouldn't be doing it, but I was heavy in my addiction, so I really, wasn't really thinking, clearly.
Okay. I guess, so I think there was a total, as far as I see, $416.27 of unpaid restitution at the time of sentencing to prison. That's been sent to the Office of State Debt Collection. Have you paid any further restitution on that?
No.
Are you willing to moving forward? Okay, I'd encourage you to do that. If you're granted parole, get a job, develop some income, making that a priority, certainly to pay back any damage that you've caused. I'd refer you to your agent or your case manager to talk about how you can reach out to the Office of State Debt Collection, set up some sort of payment plan if you'd like to, but I'd encourage you to make that a priority moving forward. Looks like, I think you terminated your first prison commitment in November 2019. After that, it seems like you kind of fell back into similar patterns of behavior, right? Was substance abuse, drug possession or use, and retail theft. Really, that is what your criminal history is essentially, is possession, use of a controlled substance, and retail theft. I think you were given a chance at drug court before you arrived at the prison, but there's some reports about you saying you didn't want to be part of that, or you wouldn't participate in residential treatment programs. Walk me through what happened on probation. You were given some chances, weren't able to be successful. What do you think prevented you from doing that while you were on probation?
At the time, I was really just frustrated because I had gotten in trouble for an association with somebody.
It went out. It froze. It froze, y'all. Let's see why it froze. Is it us? Is it us or is it them? I think it's them because people saying something. Yeah, it's them. They frozen. Come on now, we want to hear her. We want to hear what she got to say. What happened to her? Let's see what the message is they saying. Oh, they're not. The chat isn't available. Oh, something happened. Yeah, it got frozen, y'all. We gotta see if they're gonna restart it. Everybody's leaving. Okay, I'm gonna stop it and then come back and see. Let's go out and then come back and see what happened. Nothing's happening, y'all. It's still, nothing's there. Let me show it to y'all. Everybody's joining, but there's nothing there. Okay, everybody left the meeting. They joined back in again. Nothing's happening, y'all. Let me show y'all. Okay, nothing's happening. Nothing's happening, y'all. Well, that means the end of the day for us. It's been real, y'all. I'm about to get off. That was a sign for us to get off. Later. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me. We laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment